Check 1 2. Check check 1 2 3 4.
Bring this proceeding to order and go on the record. Good morning. Today is February 6, 2023. Time is 9:00 a.m. The Commission has set this time for an evidentiary hearing in the case captioned as in the matter of the application of Union Electric Company, DBA, Ameren, Missouri, for approval of a subscription-based renewable energy program. It is the Public Service Commission file number EA-2022-0245. My name is Ken Sire. I am the regulatory law judge presiding over this hearing. This hearing is taking place in the Public Service Commission hearing room, room 310 of the Governor Office Building in Jefferson City, Missouri. However, there may be counsel, and I know there will be witnesses who will be participating over the internet via Cisco WebEx. So at this time, let's have counsel for the parties make their entries of appearance, beginning with Ameren, Missouri.
Thank you, Your Honor. Jim Lowry, appearing on behalf of Ameren, Missouri this morning. The court reporter has my contact information, and also on behalf of Ameren, Missouri, Jermaine Grubbs, corporate counsel with Ameren, Missouri, and I believe the court reporter also has her contact information.
All right, thank you. For the Missouri Industrial Energy Consumers.
Diana Plesha of the law firm Curtis, Hines, Garrett, and O'Keefe, 130 South Beamiston, Clayton, Missouri, 63105.
All right. And then counsel for Walmart. All right.
Good morning, Your Honor. Tim Opitz, appearing on behalf of Walmart. My address is 308 East High Street, Suite B101, Jefferson City, Missouri, 65101.
All right, thank you. On behalf of the Sierra Club.
Ethan Thompson, appearing on behalf of Sierra Club. I'm an attorney at Great Rivers Environmental Law Center in St. Louis at 400 North 4th Street.
And
Judge, co-counsel for Sierra Club Online, Bruce Morrison, also at Great Rivers Environmental Law Center.
okay. And Mr. Thompson, THOMPSON? Okay. For Renew, Missouri.
Good morning, Elisa Greenwald for Renew, Missouri. My address is P.O. Box 413071, Kansas City, Missouri 64141.
All right, thank you. For the Office of Public Counsel.
Nathan Williams, Chief Deputy Public Counsel, appearing on behalf of the Office of Public Counsel and the public. I provided my information to the court reporter as well.
All right, thank you. And for the staff of the commission. Mr. Graham, could you hit the microphone there?
Paul Graham Entering's appearance for the staff of the Missouri Public Service Commission. The commission has my address, which is in this same building.
Okay.
Thank you very much.
All right. Are there any other attorneys here representing parties that I left out? All right, thank you. For those in the hearing room, I do ask everyone to silence all cell phones and mobile devices. For those connected via WebEx, I ask that you mute your microphone when not speaking. For those in the hearing room, please be cognizant of when your microphones are on, indicated by the green light, and when they are off. Also know that speaking within just a few inches of the microphones will make it much easier for the court reporter and those on WebEx to hear what each of us says. As far as planning, I'm sorry?
Judge, this is Commissioner Holzman. Just wanted to note my presence on the record.
All right. So noted. As far as how this day will proceed, we will be taking a lunch break today at 12:30. Depending upon where we're at that time with opening statements and what have you, we may break a bit sooner than that, but we will definitely be in recess from 12:30 until 1:30 as the commissioners have a meeting scheduled at that time. Another preliminary matter. Mark Schuerman is on the witness list, and he is scheduled to testify on behalf of the Missouri Industrial Energy Consumers. Ms. Plesha, am I saying that correctly? Okay. she would like to know if there are any other party, if any of the other parties intend to cross-examine Mr. Schuerman, or whether he can be excused from the hearing. So do any of the other parties wish for Mr. Schuerman to be available for cross-examination later when he's scheduled to testify? If not, I'll excuse him from the hearing. Mr. Graham?
Staff has no problem with that.
Mr. Williams?
As long as he's not going to appear and his testimony is just, pre-file testimony is admitted into the record, then public counsel's okay with not crossing him.
All right. Do any other parties have any objection to that, to excusing Mr. Schuerman?
No objection from the company.
All right. Thank you. And Ms. Blesky, that is, Mr. Schuerman's name is Schuerman. All right, then Mr. Schuerman is excused and is not required to appear to testify.
Thank you, Your Honor.
You're welcome. Do the parties have any other preliminary matters to discuss? All right, hearing none. As far as the order of witnesses and cross-examination, give me a second here. We will follow the order filed by the parties in their jointly proposed list of issues, order of opening statements, list and order of witnesses, and order of cross-examination. Besides Mr. Schuerman, are there any changes to that list and order of witnesses?
Your Honor, Paul Graham speaking for the staff. We have a witness, Jane Doherty.
Uh-huh.
And
Mr. Graham, could I have you just bring that microphone a little closer?
surely. We have a witness, Jane Doherty, who's coming from St. Louis, I believe, and she has requested, and counsel have not objected to the proposition that she be allowed, that we fit her in at some point, regardless of where we otherwise might be tomorrow for Tuesday, so that she can make plans. Now, I'm not saying that we're reordering any witnesses. We'll kind of take that matter on the fly, and that's the agreement if it's okay with the commission.
Okay. I don't think that'll be a problem. Thank you. All right. I'll give the parties the opportunity to make an opening statement. Mr. Lowry, would you like to make an opening statement on behalf of Ameren, Missouri?
Yes, I would. Thank you, Your Honor. Your Honor, I do have a slide deck, and I'd just like to mark it for identification. I don't intend to offer it, but I've got copies for you and the commissioners in the court order and my co-counsel standing copies to the other parties. I believe it would be Exhibit 13 for identification. It just consists of information that's already in pre-filed testimony, but I thought it'd be more convenient for the commissioners to be able to have it in their hands this morning.
All right. I'm not sure. I'm not sure we captured all that, but Mr. Lowry, you were telling me that you have.
I'll try that again. So, Your Honor, I have a handout, a slide deck that's also on the screen that I suggest we mark for identification as Exhibit 13. I don't intend to offer it, but it just contains information that is in pre-filed testimony in the case, and I'm providing it just so it's a little easier for the commissioners to follow along.
All right. Understood. Thank you. All right, Mr. Lowry, you can proceed.
Good morning, and may it please the commission. My name is Jim Lowry, and I, along with my co-counsel Jermaine Grubbs, are representing Ameren, Missouri in this important case here today. Why do I say this is an important case? After all, it involves a single 150 megawatt renewable energy facility that, relative to Ameren, Missouri's overall generation fleet, is not very big. So why then is this relatively small renewable generation addition important, not just to the company, but I would respectfully submit to the commission as well. It is important because, as the evidence in this case will show, Ameren, Missouri, starting now, has a clear present need to begin adding renewable energy resources to its generation portfolio so that it can begin to address a shortfall in its expected energy position that, even under normal or base planning assumptions, is expected to arise in less than 5 years. If I could direct your attention to, and I believe it's up there, to slide number 2 in your slide deck in Exhibit 13. While under base planning assumptions, Ameren, Missouri expects to be long energy in 23 and 24 by about 5 to 7 million megawatt hours, while Rush Island is still a part of its fleet, that length is cut dramatically in 2025 and becomes a projected shortfall by 2028. If the company is unable to add new resources, that's the picture we have. And new resources for this purpose are any resources beyond its existing resources, plus the Huck Finn facility, which the parties have agreed in a separate docket that's pending should be added for renewable energy standard compliance purposes. The shortfall I mentioned could arise earlier if you take a look at slide number 3 of your slide deck, in a case where high carbon prices are imposed on Ameren, Missouri's fossil generation units. In that case, the shortfall occurs in less than 3 years from now, by 2026. And by 2028, the company's energy position would swing from being about 5 to 7 million megawatt hours long this year and next to being short by that amount by 2028 and for a couple of years after, a swing of about 10 to 14 million megawatt hours. As company witness Aurora puts it, whether one assumes the base planning assumptions or assumptions that other events or circumstances arise that could lead to an energy shortfall sooner or an energy shortfall that's greater than these base planning assumptions indicate, the company's generation position is becoming and very soon will be dramatically different than it was when Ameren, Missouri had a historical 15% to 20% energy buffer, which it's enjoyed for probably decades. That buffer existed because Ameren, Missouri had those 2 baseload coal units, Rush Island and Merrimack, one of which is already off the system and one of which will be in a couple of years. The company's evidence will show resource decisions. And when you think about it, that's what this case really is. It is a resource decision that the commission is being called upon to make, since under the law, utilities cannot add generation without the commission's approval. The evidence will show that resource decisions need to be made in the context of the planning environment and circumstances that exist now, and not in the context of a planning environment that the company faced in the past. That environment doesn't exist anymore. And because of that, it requires we, and I would submit the commission, to look at resource decisions differently than they have in the past. In that earlier planning context, the company would agree that one would look in isolation at a particular resource and a narrowly defined need that resource might meet. And in a business as usual environment, that approach made sense. But the evidence in this case will show that we are no longer in a business as usual planning environment, but those that oppose the CC in this case, I would submit, are proceeding as if we are. To the contrary, the industry, our region, the RTOs in which Missouri electric utilities operate, including MISO, are well into making a move to greater reliance on clean, renewable energy resources. This move is already happening all around us. As the company's evidence will show, in these times, resource planning can only be rationally conducted by recognizing and then accounting for the fundamental changes that are happening in the industry and then implementing plans that account for them appropriately. If we take a business as usual approach when it's not business as usual, Ameren, Missouri, the commission, we will all fail to take the steps that are needed so Ameren, Missouri can reliably, sustainably, affordably, and in a timely way transition its fleet from the old fleet that we have today to one that's going to look significantly different. Put another way, by treating the resource planning environment as if we are in a business as usual environment when we aren't, I would submit that staff is focusing on a problem different from the one we actually face today and therefore reaching the wrong conclusion. The company's testimony demonstrates that Ameren, Missouri is not the only one saying this, not by a long shot. It is being said by other state regulatory commissions, literally all around us, who recognize the situation and are allowing their utilities to add significant renewable energy resources to address it. It is being said by entities like NERC, the North American Electric Reliability Corporation, which, as I think you know, is the reliability coordinator for the bulk transmission system, which is warning us of what is happening in MISO as early as next summer, and importantly is telling us that we need to look at resource planning decisions differently than we have in the past. That is, our planning needs to focus on different things, not just whether we have under base planning assumptions a protected capacity shortfall on paper at a particular point in time, but looking at what, specifically focused on energy needs in all seasons, and that is what Ameren, Missouri is doing. These voices are telling you that we need to solve the problem, a particular problem. That is, we need to address the fundamental supply and demand changes that are happening simultaneously in our industry right now. And we need to recognize, NERC tells us, that while we are going to have baseload resources and dispatchable resources on our system, and Ameren, Missouri's plan calls for that, we are also going to have a much greater reliance on renewables. These facts demonstrate that Ameren, Missouri's request to add this solar facility in this case, and its plan to add more renewables in the intermediate to longer term, is most definitely not unprecedented, as staff's witnesses claim. So why a solar facility? Why now? First, the company needs and will need energy in all seasons, and Boomtown will produce energy. Second, the facility meets the specific needs of the subscribing customers in the proposed Renewable Solutions Program, which I'll talk more about in a moment. And those subscribing customers make this needed facility cheaper for all customers, which is an obvious win-win. And third, as a practical matter and to mitigate real risks that we face, the company cannot sit by and let this and other good renewable resource projects pass it by if it's to meet its energy needs in the near, intermediate, and ultimately the long term. With respect to the first point, the evidence will show that Ameren, Missouri is projected to have energy shortages throughout the year, including in the summer, when both the Ameren, Missouri and MISO systems peak. Solar resources like Boomtown will absolutely be valuable during the summer. And I would submit to you that the evidence will also show that those resources, while clearly not as valuable in the winter, provide more value than you might assume. Now, Boomtown, of course, a 150 megawatt facility, cannot possibly solve Ameren, Missouri's energy situation by itself. It's not going to reverse the shortfall that may exist in MISO as soon as next summer, but it will help, and it is a start. And I would submit that it would be a no-regret addition to the portfolio. With respect to the second point, another reason this facility should be built now is that it has been fully subscribed by the 10 subscribers who have entered into contracts subscribing to Phase 1 of the Renewable Solutions Program. I'll talk more about that in a moment. But it's important to note that there is no plausible scenario where the existence of the program does not make the revenue requirement associated with the Boomtown resource lower than it otherwise would be in the absence of the program, given that we need the facility irrespective of the program. On a practicality side, given the amount of energy the company needs, again, as soon as 2028 in base planning conditions and sooner if a myriad of risks that could arise do arise, the company simply must take advantage of good renewable projects as and when they are available. Consider the evidence that Mr. Aurora's testimony contains. The company did an RFP for wind and solar projects a couple of years ago. Developers proposed 51 different projects. The company, as you might expect, diligenced those projects carefully and had to eliminate 42 of them for a variety of circumstances, constructability, transmission, they were not competitive, cost, whatever. That left the company with 9 potential projects. The company diligenced those 9 projects. 2 became unavailable. 2 were not, it appeared, going to qualify for tax credits, which made them non-competitive. They were going to be higher than market projects. And 1 couldn't be built because it had a geotechnical issue where they wanted to build it. That left 4 projects out of 51, 2 of which are the Huck Finn and the Boomtown projects. Good renewable projects are very difficult to come by, and they are difficult to implement. On the risk side, the evidence will show that inaction also poses real risk. That is, the risk that when the company needs energy, it simply will not have it, because if it waits, it will not, as a practical matter, be able to implement the energy resources it needs in real time when it needs them. If you go back to that first figure I showed you, slide 2 in your deck, you may recall that I noted it showed the energy position under normal or base planning conditions. But the evidence will show that conditions are often not normal. The evidence will show that a litany of events that have occurred in just the last few years, and that certainly appear to be occurring with greater frequency if they happened again, whether together or apart, could pose a real risk to Ameren, Missouri's energy position at any time starting in 24 or 25 and for several years thereafter. Consider Winter Storm Uri. That could happen again, and perhaps in some ways it did in the 4 days before Christmas that we probably all remember from a few weeks ago. In 2021, the Callaway plant suffered an 8-month forced outage. That did not pose severe risk to Ameren, Missouri's ability to meet its load, in large part because we had Merrimack and Rush Island on the system, and it did not expose the company to huge exposure to the market for the same reason. But if that were to happen again, once those units are gone, which will happen very soon, the risk profile would be much different. And there could be other major generating units that also are forced out besides Callaway. Last summer, you might recall, the company was forced to reduce the dispatch of its coal plants because the railroads were not performing and getting the coal to the plants that we needed to make sure that we would have energy on, the hottest of the hottest summer days. Last year, MISO's planning a resource auction. Just last year, it cleared at cone, the cost of new entry. What does that mean? It means that the capacity offered to serve load in MISO was less than the expected loads in MISO. And finally, environmental regulations could force an earlier than expected closure of a major plant, for example, the Sioux plant. Or if they don't force a closure of a plant, they could require those plants to dispatch significantly less than we might expect in these base planning assumptions, which would have a major effect on the energy position. As the company's witnesses explained, when Ameren, Missouri was long, when it had that 15 to 20% buffer, the evidence shows, when MISO wasn't designated as a high-risk zone, if you look at slide 4, that slide is from a November 2022 NERC report, where NERC designated MISO as a high-risk zone. I don't think that's ever happened before. When those kinds of circumstances didn't exist, when Ameren, Missouri had that length, and when Ameren, Missouri had a greater ability to lean on the market than it does today, that buffer of energy I talked about in both the market and in Ameren, Missouri, it mitigated those risks significantly. But we are no longer in that situation, and so those risks are much more important and must be planned and accounted for. There are other key pieces of evidence that the Commission should keep in mind in this case. First, as can be seen on slide 5, if the company proceeds to add the Boomtown facility and then incrementally add additional renewable energy resources in the intermediate to longer term, it is projected to meet its customers' energy needs entirely. And if you go to slides 6 and 7, even if we get in, I can only show one at a time obviously, but even if we get in a situation, for example, where we have high carbon prices or other extreme circumstances, the company is still expected to meet its customers' energy needs, not by as much, but under that plan, it is still expected to meet them. But again, only if we add Boomtown and we continue to add like resources steadily over the next few years. It should also not be overlooked, and I don't think that's gotten probably as much attention in this case, but the company's approach as compared to the alternative business as usual approach is expected to meet those needs at a lower net present value of revenue requirement than the alternative case. And as you know, one of the primary criteria for resource planning under the Commission's rules is net present value of revenue requirement. The evidence will further show that resource planning is not a mere, quote, planning exercise, as staff claims. Consider that the IRP rules require that we adopt a preferred resource plan. They require that we have an implementation plan, and then they call for an implementation period, which is a short-term period between triennial IRPs. The idea that utilities should not come to the Commission and say, I want to implement a resource that was contemplated by my implementation plan, but the Commission should really not give that resource planning exercise much weight, I would submit just doesn't make sense. Now, before concluding my remarks, I want to pivot away from discussing the Boomtown facility a little bit and focus a little bit more on the Renewable Solutions Program. As the company's evidence will show, the program is an innovative way for the company to partner with its larger customers that desire to support the deployment of greater renewables. What we're doing is we're taking resources like Boomtown that we already need, and we're using them to support the program. Under the program, the subscribers pay a fixed charge for the amount of renewable capacity that they need, and then they receive benefits in the form of reduced energy cost in direct proportion to the output of the resource. This approach provides these customers with greater choice and it results in them contributing to a part of the resource's cost, which lowers that cost of that resource that will be providing capacity and energy for the company, all the company's customers, for the benefit of all customers. And the approach transfers production risk associated with the resource away from the non-subscribing customers to the subscribers, which also benefits all customers. Indeed, the company is proposing a tracking mechanism to make sure that all the revenues from the program will get to all customers, not just subscribers, all customers between rate reviews. Without the tracker, that might not happen. As company witness Rob Dixon testifies, meeting these customers' needs, giving them choice is critical to making Missouri more attractive, more competitive, to attract new businesses to the state or to attract expansions of businesses that already exist here. Either of those attractions provide economic development benefits, jobs, taxes, and increased electricity sales over which we can spread our fixed costs more broadly and lower rates for all customers. As I wrap up my remarks, the last thing I would like to do is remind you of this Commission's own statements reflected in Mr. Will's surrebuttal testimony, and I've compiled them in the last 4 slides of this deck. I'm not going to read them to you, obviously, but those statements, I believe, clearly demonstrate that the Commission recognizes and values the importance of the electric utilities under its jurisdiction, adding renewable energy resources. And I have highlighted, I think, some of the more salient statements this Commission has made that are particularly pertinent to this particular case, and I encourage you to read them. In this docket, the Commission has the opportunity to follow through on the spot-on statements by approving the CCN for the Boomtown facility so Ameren, Missouri can begin meeting its energy needs, and which in this particular case is to be partially paid for by the subscribing customers. Lastly, when our witnesses take the witness stand, I would encourage you to ask them questions because that's what they're here for, I think, to answer your questions in particular. I appreciate your time and your attention this morning. If anybody has any questions I can answer at this time, I will do my best to do so. Thank you.
All right. Thank you, Mr. Lowry. Before we get to potential questions from the commissioners, I just want to pause here for a second and go over a few terms for the sake of our court reporter who has kind of been thrown into the deep end of the pool here. So you mentioned, of course, the main topic of this hearing is the Boomtown Solar Project. I just want to make sure she understood BOOMTOWN, okay? You mentioned Rush Island. You mentioned the Sioux plant. So
spelled just like like you would expect.
Well, unless you expect it.
S-I-O-U-X.
You did mention NERC. Could you spell that out?
Yeah, N-E-R-C, North American Electric Reliability Corporation. MISO, I think, would be one, Judge, and I didn't actually define it, but that's the Mid-Continent Independent System Operator.
And you mentioned the RIP rules.
IRP rules.
Right, IRP.
Integrated Resource Planning rules, IRP, yes.
And CORE, cost of new entry.
CONE, I believe, Your Honor.
CONE, I'm sorry.
C-O-N-E, CONE.
All right. Ms. Belsky, is there anything else?
Certainly, if you have any questions, we can offline help you with your transcript. Happy to do that.
All right, Chairman Roop, do you have any questions for Mr. Lowry?
Thank you.
All right. Do any of the other commissioners have any questions for Mr. Lowry? All right. Sounds like there's
No
none.
questions, Judge. Thank you.
Thank you, Judge.
Thanks.
No questions, Judge.
Thank you, Commissioner Coleman. All right. Ms. Pleshia, would you like to make an opening statement on behalf of the Missouri industrial energy consumers?
Yes, thank you, Your Honor. May it please the Commission. Ameren has more than met its burden of proof in this case under the Commission's standards for granting a CCN. I think that the core issue, and most parties agree in large part on this, is that under the Commission's test for granting a CCN, that the issue of necessity is where the parties have their dispute, and the question ultimately is is the project in the public interest. The commission has never defined necessity as being a current immediate need of the utility. It appears that the staff of the commission is viewing the renewable resource need as not appropriate for a CCN in this case because it's too far off, or Ameren has currently sufficient capacity. But that isn't the way that utilities plan resources, especially when solar projects, as the evidence shows, take 5 to 8 years to develop. There are many risks, as Ameren points out, and as MIEC witness Morris Brubaker points out, that any particular renewable project will not be achieved. And so it's important for the utility to get in front of those issues. It's important for the utility to have time to make those plans. And there's a very fierce competition right now among utilities and among private companies a fierce competition to grab the solar resources needed, the equipment, the facilities, the land, and then there are numerous approvals needed. Mr. Brubaker, in his testimony, provides 4 examples of utilities that were not able to secure solar resources due to, well into the project approval process, having one of these risks develop and derailing the entire program. And so it really does happen that if a utility doesn't have plenty of lead time, there are so many things that can go wrong that you can never be absolutely sure that one of these projects will actually transpire. So it's very important that renewable energy sources are part of the utility's long-term planning and not just in time. It wouldn't be in the benefit of the utility or its customers for Ameren to not increase its renewable portfolio, nor would it be in the benefit of the reliability of the system in the future. The staff notes in its testimony that the IRP of Ameren is not a basis for the commission to approve a CCN. And we do agree with that insofar as it goes, because the commission, when it approves the CCN, is approving the utilities taking on the risk of constructing a project. But that risk always remains with the utility. The commission never makes a decision of how the utility should run its business, even though it regulates and supervises that. Ultimately, the utility bears the cost and the risk if a project turns out to be imprudent. And the commission does not decide decisional prudence in an IRP process, and therefore that risk remains with the utility, and that's very important because the commission does have that backstop and the protection. Ratepayers have the protection that if something were to go wrong and the utility's planning turned out to be a bad decision at the time it was made, then ratepayers can be protected by the commission. So while the staff notes that decisional prudence is a protection, they also at the same time seem to disregard that as a protection for the future risk of ratepayers. And I think that in that respect, they're misconstruing the public interest because there is a protection already there. I also want to note a couple of other significant issues. We also present the testimony of Mark Sherman, who is the Director of Global Supply Resources for Bayer, which was one of Missouri's most important companies, with 2 large facilities on Ameren's system and also a facility in Kansas City. Obviously, it's a global company, but it's extremely important in Missouri. And Bayer's testimony is representative of other companies who are large industrial users who don't find it feasible to build and construct their own renewable resources. They want to use their CapEx, which is limited, to invest in their business. And it makes sense to them to have a program like the Renewable Solutions Program, which gives them an opportunity to buy power far into the future, to secure a resource that helps them meet their corporate goals, that also helps them to meet their reliability needs in the future. It gives them the opportunity to do that without spending that CapEx on something that the utility can more cost effectively provide. It also, in their opinion, is part of their corporate responsibility as well. But the argument we're making isn't that this program only benefits industrial consumers. It's a factor for the commission to consider that having these resources in the state is truly important to the state's economic development. So many companies right now, and the testimony of Morris Brubaker demonstrates this, a large percentage of companies actually would not locate in a state where they couldn't obtain renewable resources. And so it really will hurt the public interest to spread costs and have fixed costs spread over more customers, and large industrial customers benefit the system by having the fixed costs covered. And so it does create a lot of risk for all ratepayers if we don't have something like the Renewable Solutions Program that really large customers can count on to meet these needs. There also is another factor, which is that it's not possible in Missouri legally for customers to just do a PPA. Ameren, Missouri is monopoly, and Missouri customers are not allowed under current law to just go out and try to get another supplier through a PPA. So this is really the most feasible option for them. The fact that so many industrial consumers and commercial consumers have signed up for the program and that it's actually oversubscribed shows that there is an important service being provided by the RSP. And for this reason, the public interest standard for a CCN is met because a service is being provided that is useful to consumers. And that is part of the factor that the commission has always looked at when deciding a CCN. The last issue I want to address is the benefit that industrial customers and other subscribers of the RSP should receive when they receive a renewable credit. The testimony points out that the Inflation Reduction Act changed the picture in this case, that the original filing that Ameren made was based simply on the Build Back Better plan, and that provided for investment tax credits, which had a high cost because it requires a tax equity partner. When a month after the Ameren filed its case, the Inflation Reduction Act was passed, and production tax credits, which are much more lucrative for the utility than the investment tax credit, took effect. That benefit goes to all renewable resources, and the benefit of the Boomtown project has greatly increased because of that. Right now, the way the proposal stands is that industrial consumers and other subscribers do not get the benefit of the production tax credits. Since the idea of the RSP is to share risk and cost and benefits, it would be inequitable to not provide any of that benefit to the subscribers who are taking on risk to the benefit of the system in subscribing to a 15-year program. So we would urge the commission to look at the testimony of Morris Brubaker and ensure that those tax credits are reflected in the credit to subscribers. And I'm happy to answer any questions.
All right. Chairman Roop, do you have any questions? Do any of the other commissioners have any questions?
No
Question, Judge, thank you.
All right. And was that Commissioner Kolkmeyer? For the sake of the record.
Commissioner Holzman. Commissioner Holzman.
All right, thank you.
And Commissioner Coleman, no questions.
Okay.
And Judge, if I do, I'll jump in at the time.
Understood. Thank you.
Thank you.
All right. Thank you, Ms. Palacio. All right. Mr. Opitz for Walmart.
Good morning, and may it please the commission. I'm Tim Opitz, appearing on behalf of Walmart, Inc. As a little background, statewide, Walmart operates 156 retail stores and 4 distribution centers, employing over 45,000 associates in Missouri. In fiscal year ending 2022, Walmart purchased $7.8 billion worth of goods and services from Missouri-based suppliers, supporting over 70,000 supplier jobs in Missouri. Within Ameren's territory, Walmart has 52 stores and 1 distribution center. Walmart has long had aggressive and significant company-wide renewable energy goals, and beginning in September of 2020, Walmart announced new targets, including to be supplied 100% by renewable energy by 2035 and 0 carbon emissions in its operations, including fleet vehicles without the use of offsets, by 2040. Walmart pursues various pathways to meet its renewable energy goals depending on the cost, risk, and operational factors for any particular location. Here, Walmart is among the customers that have already made a commitment to capacity under the Renewable Solutions Program. Walmart's witness, Mr. Andrew Teague, pre-filed rebuttal and surrebuttal testimony outlining Walmart's interest in the program and an overview of the ways Walmart meets its renewable energy goals. He will be testifying virtually later on during the hearing. Lastly, Walmart asked that the Commission approve the requested CCN and the RSP program tariffs in order to allow Walmart to continue its progress towards meeting its renewable energy goals. And with that, I'm happy to answer any questions.
All right. Chairman Root, any questions? All right. Any of the other commissioners? All right, hearing none. Thank you for your opening.
Thank you, Judge.
All right. Mr. Thompson, would you like to make an opening statement on behalf of Sierra Club?
Good morning, and may it please the Commission. My name is Ethan Thompson, and I'm an attorney with Great Rivers Environmental Law Center in St. Louis, and representing Sierra Club in this case. Sierra Club respectfully asks that the Commission grant the requested certificate of convenience and necessity for the Boomtown Solar Project. I offer these points in support of granting the CCN. First, energy is a foundational component of electrical service. Any interpretation of need under the Tartan factors must be founded on the fact that customers need electric energy in addition to other services such as capacity and electric grid stability. The Commission should find that need is not defined strictly by whether a resource meets the company's firm capacity needs, but also by whether it can economically meet the company's energy needs, as well as the company's need for a hedge against high fuel prices. Second, Boomtown generation will displace generation from other generators every day that it operates, and will therefore benefit customers by reducing exposure to fuel price risk, and will benefit the environment by reducing pollution. Because solar is a zero marginal cost resource, it displaces more expensive fossil fuel generation on the MISO grid, which ultimately drives down the cost of market energy used to meet the company's energy needs. Third, Boomtown will also benefit ratepayers by reducing energy risk associated with market exposure and fuel price volatility. Fourth, the Boomtown project will have significant capacity value. Standalone solar has significant capacity value in spring, fall, and especially summer, which remains a period of significant risk to the system. Standalone solar also provides some capacity in the winter, and when battery storage is added in the future, the firm contribution of solar in the winter will increase. Lastly, Ameren needs to get started on its generation transition. Staff and OPC have identified operational issues associated with solar generation. Ameren and MISO need experience operating solar projects to begin to work through those issues. Further, Ameren has no choice but to transition its generating fleet. Its Labadie coal plant was built in the 1970s and is approaching the end of its useful life. Ameren has no choice but to begin to replace its legacy generation, and it must start this transition today. Thank you, and I'm happy to answer any questions.
All right. I'll ask you to clarify for the court reporter, you had mentioned tartan factors, Tartan, correct?
Yes, Your Honor.
And then the coal plant that you just mentioned.
Labadie.
Can you spell that for the court reporter, please?
Sure. Labadie.
All right. Thank you. Chairman?
Yeah, just to clarify, your first point was that the solar facility will be displacing other generating factors, but in Ameren's opening and their information from MISO and NERC that there's going to be a shortfall. Does your organization believe that there will be a shortfall in the next several years?
I believe that our position is consistent with Ameren's on that issue.
Okay, thank you.
All right. Do the other commissioners have questions? All right. Hearing none. Thank you, Mr. Thompson.
Thank you.
All right. Ms. Greenwald, would you like to give an opening statement on behalf of Renew Missouri? Thank you.
Good morning, and may it please the Commission. My name is Elisa Greenwald, and I am appearing on behalf of Renew Missouri. For many years now, we have advocated for the deployment of renewable energy in the state of Missouri because we believe that renewable energy is a strong driver of economic development. We have advocated before legislators, county commissioners, the utilities, and this commission that businesses care where their energy comes from and that they factor this decision into their ability to move operations to Missouri or keep operations in Missouri. And for many years now, Commission precedent defining the public interest has acknowledged the ability of clean energy to provide health, cost, and environmental benefits to the general public, as well as its ability to make Missouri businesses more competitive. Ameren's application for the Certificate of Convenience and Necessity and the Renewable Solutions Program demonstrates just that. The large companies that have agreed to participate in this program use massive amounts of energy, and they're concerned not only about their environmental impact, but they are also interested in the cost savings that they can achieve by utilizing solar energy. These corporate sustainability goals are not simply altruism, but real business decisions that have determined that offsetting their usage with renewable generation is in the best interest of these companies. Ameren's decision to work with these large customers to meet their needs makes business sense in the same way that it makes sense to offer renewable solutions programs to residential customers that are sustainability minded. Overall, approval of the Renewable Solutions Program and the CCN serves the public interest in many ways that the Commission has consistently recognized, yet are ignored by staff and OPC in their testimony. These factors include developing economical renewable energy sources while reducing the amount of carbon dioxide emitted into the air, as well as helping Missouri corporations perform more competitively. This is especially important because the Commission has broad discretion to grant a CCN when it determines that the public interest is served, even if there is not immediate physical need for the resource. Renew Missouri encourages the Commission to approve Ameren's request for the CCN, as well as the Renewable Solutions Program. Doing so serves not only Missouri businesses, but the state interest as a whole. Thank you, and I'm available for any questions.
All right. Chairman Roop, do you have any questions? All right. Any of the other commissioners have questions? All right. Thank you, Ms. Greenwald.
Thank you.
All right, Mr. Williams, on behalf of the Office of Public Counsel.
May it please the Commission, my name's Nathan Williams, and I'm here appearing on behalf of the Office of Public Counsel and the public. It's our position that customers' primary concerns are with getting electricity and getting it at an affordable cost. Reliability is a very important factor in that, and that's been demonstrated by the storms that we've seen February of 2021, February of 2022, December of 2022. We saw extremely high prices for energy in the markets. That was because of a shortage, basically, in those markets of energy, which drove the price up. Our concern is that with Ameren's planning is not that it's with renewables, but that it's not providing sufficient energy during those times of high need and high cost. The solar project will not do that. It will provide additional energy during the days in the winter, but it will not at night. And if you note, all the times I pointed out when energy prices have spiked severely have been during the winter time. Also, as to entities that are customers that are desirous of having renewable energy as their primary source, Commission should follow principles of cost causation on that. And if there's a certain class of customers that want to have their energy prices based upon renewable energy sources only, then set up a separate class for that that's based on the cost of generating that electricity. It may very well be lower during times of normal operation, but they'll also be exposed to those very high prices during shortfalls. Dr. Jeff Mark is our witness in this case, and I ask you to ask him questions to flesh out Public Counsel's issues with Ameren, Missouri's application. And I will tell you, we're not opposed to renewable energy. What we're looking for is that there's firm dispatchable sources of energy that replace the current sources that Ameren, Missouri is planning to retire. It's coal generation, it's gas generation. As long as the fuel's there, is firm generation. Utility can control the dispatch of that readily. With intermittent resources, it's there whenever the source of energy is there. The electricity is there when the source of energy is. It is not otherwise.
All right. Chairman Roop, do you have any questions?
What is your definition of firm energy? You can call on it at any time that you need.
Mr. Williams, I'm going to go ahead and have him repeat that question.
Sorry, I didn't use the microphone. What is your definition of firm energy?
That it's available when you need it. Nothing's 100%, but definitely big thermal units are more available than something like solar, which is only available during the daytime.
All right. Do any of the other commissioners have any questions for Mr. Williams? All right, hearing none. Mr. Williams, I appreciate your opening.
Thank you.
All right, Mr. Graham, on behalf of the staff of the commission.
Thank you. If it please the commission, I'm Paul Graham, representing the staff of the Missouri Public Service Commission. After listening to what I've heard this morning, it strikes me that the key word is risk and risk management. And in this particular case, the argument is that the risks are so compelling that we need to alter our definition of prudence. Not so. The fact that we can do a prudence review in the future is not a license to not do due diligence now, and certainly is not a license to be reckless now. Witnesses for the staff today will be, or in the next couple of days, will be Sean Lang, Brad Fortson, Michael Stallman, Cedric Kunigan, Jane Doherty, Jordan Hall, Song Wan, and Jay Lubert. Ameren has presented an application for a CCN for a 150 megawatt solar generation facility to be constructed in White County, Illinois. Ameren is also asking for approval of a renewable solutions program. Staff opposes both. The global question presented is whether the Boomtown solar project is necessary or convenient to the public service. In answering this question, the Commission looks to the Tartan factors. Should the Commission find that the project is needed? Should the Commission find that it's economically feasible? Should the Commission find that Ameren has the ability to finance the project? should the commission find that Ameren has the ability to construct the project. Should the commission find that the project is in the public interest. What you've heard today so far is that staff takes a narrow position and defines need in terms of what exists right now. Not so, not so. Staff appeals to this commission to look at the long-term picture, see where we end up here as predictable on the basis of the evidence, and ask itself whether Ameren has sustained its burden to show that this project is needed. It is staff's contention that Ameren, Missouri has not demonstrated that the project is needed in likely and inefficient way to meet other near-term and long-term ratepayer needs. To restate, Ameren has not demonstrated that the project is needed and that it is likely an efficient way to meet either near-term and long-term ratepayer needs. For that reason, and also because the project does not justly and reasonably allocate the risks that you have heard from start to finish this morning, does not allocate those risks fairly and reasonably to all of the stakeholders, including the shareholders. The staff contends that this project is not in the public interest. If the need is so great, if the risk is so great, why is the risk not being shared fairly and equitably? That's the question presented in this case. It is also staff's contention that if the project is approved, the Renewable Solutions Program should nevertheless be rejected. As staff will show at the end of its operational life, the Boomtown project's expected revenue will not have met the costs, and directly or indirectly, its return in rate base for Ameren shareholders will, from start to finish, be subsidized by Ameren's ratepayers. This is a principal reason that the Commission should find that the Boomtown project is not in the public interest and reject the project. And it's the principal reason that the Commission should find that the project does not meet the fifth Tartan factor. It is also the principal reason for rejecting the RSP, the Renewable Solutions Program. Although called a solutions program, the Renewable Solutions Program actually does little to offset the capital investment expenditures of the solar facility, and thus the problem is not a solution to the problem that the Boomtown project will never pay its own way. Active in this case from beginning to end has been an issue of what is need. The staff contends that the project does not meet the Tartan need requirement. Ameren's principal argument is that because the country needs to move away from coal-fired energy sources, and because the Boomtown project is a renewable energy facility, the project meets a general public interest need. And then to cross the Tartan need finish line, Ameren contends that the project addresses a capacity need and an energy need. The question of need is for the company to demonstrate in each case, addressing all of the material facts and circumstances in that case. Thus, need is defined by the shortfalls or problems with continuing to serve ratepayers, which the company contends its specific project, here a solar facility, addresses. Whether the project specifically proposed actually addresses those shortfalls and problems addresses the question whether that specific project is needed. Thus, if a project does not actually address the identified shortfalls and problems, it is not needed. One may need a Phillips screwdriver. One may need to put a Phillips screw into something. The fact that the insertion of a Phillips screw is needed does not justify buying a flathead screwdriver. It won't work. The fact that the Phillips screw is a life or death matter and that we've got to get that screw in the hole right now does not alter the fact that a flathead screwdriver won't work. And so the flathead screwdriver is not needed for this job. Understanding the concept of need, generally speaking, as I have described, is not hard. In fact, the definition's legal basis is obvious. To be needed, a project must be able to address or improve the utility's ability to provide safe and adequate service at just and reasonable rates. If it can't do that, it's not needed. To the extent a project is not adequate to address a need at just and reasonable rates, it does not satisfy the Tartan need requirements. And that's so even if some problem must be solved. Staff contends the Boomtown project will not, simply cannot, all things taken into consideration, provide service which is both, prong one, adequate to meet Ameren's identified capacity and energy needs, and will, prong two, do so at just and reasonable rates. Looking at prong two first, it is undisputed that taken in isolation and without resorting to speculation that market and other conditions will change in the future, the Boomtown Solar Project will not end up at the end of the day in the money. At the end of its operational life, it will not have broken even. Over its life, revenue specific to Boomtown will not cover its costs without resorting to the assumption that things change. The argument here is that we have to change because of all of the risks, but the case does not acknowledge, Ameren does not acknowledge that the solution to the problem is also based on the assumption of risks, that things will not happen that Ameren hopes will happen. So at the end of the day, ratepayers will be subsidizing a deficit. And from first to last, throughout its entire operational lifespan, the project, hear me out, the thing will be negative at the end of the day if things don't change. But from the beginning to the end, it will be in rate base to the benefit of the shareholders. Think risk management. Is that a fair and reasonable way to manage risk? That's the just and reasonable prong, and I'll return to it in a minute. Ameren contends that Boomtown is needed to help transition away from fossil fuel energy sources, and specifically to meet its capacity and energy needs. Ameren, in essence, contends that Boomtown is needed to provide adequate service. Now, what is exactly involved with capacity requirements? Capacity refers to the ability to produce energy at a point in time. The specific capacity need which Ameren has identified is subject to two competing factors. Factor one, fossil fuel facility retirements. On the one hand, Ameren's capacity to produce energy will be affected as fossil fuel facilities are retired during the future. Everything being equal, a fossil fuel facility retirement will reduce Ameren's capacity. That's one driver. The second driver, MISO. On the other hand, although energy shortfalls occasioned by weather, sunlight, market, and so forth factors can be addressed through MISO, Mid-Continent Independent System Operators, relying exclusively on MISO for the long term to cover capacity shortfalls occasioned by fossil fuel facility retirements is certainly not a plan for all of the reasons that Mr. Lowry gave us in his opening statements. For one thing, MISO requires that a company meet certain capacity minimal thresholds and will fine the company if the company does not have that capacity. To meet those increasing capacities demand over time, flanked on one side by fossil fuel plant retirements and flanked on the other side by MISO requirements, Ameren proposes over time to build the Boomtown project and then phase in other such projects. Now, pivoting back to the prong two, just and reasonable rates. The problem with Ameren's project is that phasing in more and more solar plants exactly like Boomtown to meet deficits created by the retirement of fossil fuel facilities makes no mathematical sense. If the Boomtown project will not be in the black at the end of the day, then 9 of them won't either. Why 9? Remember, we are talking about keeping up with capacity requirements. Ameren has identified 2027 as the first year that the company will not have enough capacity to match peak winter demand. The simple fact is that Boomtown and other solar facilities will only get credit from MISO for 6% of the total capacity of the resource when capacity is needed for a peak hour on a January day due to the retirement of one fossil fuel facility. For a facility which will be in rate base, making money for the shareholders, but ending up with a deficit that's balanced in charges to ratepayers at the end of its operational life.
Your Honor, I hesitate to interrupt Mr. Graham, but a highly confidential number was just mentioned that shouldn't have been mentioned in public session. So I guess I could ask the commission to at least redesignate that in the transcript and remind council that commercial terms, costs, and so on are all highly confidential in this docket.
Beg your pardon. Thank you.
Yes.
Adding-
And I will make sure I cover that part when I review the transcript.
Adding solar assets to meet winter capacity needs is an inefficient use of resources. The winter capacity shortfall subscribed by Ameren would require 9 projects similar to Boomtown to satisfy the relatively small capacity shortfall expected in 2027. The number of projects and the subsequent cost to ratepayers would grow to more than 56 times the amounts we are talking about for this case if Ameren were to fulfill that need via solar resources. For context, 56 such projects may cost in excess of $17 billion. Staff contends that a facility described by these metrics is not one which provides adequate service at just and reasonable rates. Boomtown is described by these metrics. An asset that is economically inefficient is an economically inefficient means of fulfilling identified ratepayer needs, shifts risk to ratepayers while increasing shareholders' profits. That dynamic is utterly unbalanced and directly contradicts the public interest. And Ameren knows it. Ameren is also projecting a need to build a combined cycle fossil fuel in around 2030. And I don't know if the cost of that is confidential, but it is high. And why is that? Could it be because Ameren knows that addressing both its capacity and its future energy needs with a gigantic fleet of boomtowns is simply not a plan? Actually off the charts impossible. John Adams was a lawyer before he was president and once argued to a jury that facts are stubborn things. You may have all seen the movie. It's a stubborn fact that the price of a gigantic fleet of boomtowns is inconceivable. It is also a stubborn fact that even if Boomtown and future boomtowns are hedged by a future combined cycle fossil fuel plant fleet, Ameren's own projections indicate that absent market and other changes, its modeling, its IRPs and its modeling, on the basis of those, it cannot be predicted without assuming that things change, that the revenues will materialize that make this project positive at the end of the day. So Ameren will continue to pay for energy needs of its ratepayers via the MISO markets throughout all of this, whether or not Boomtown is added to the generation portfolio. Now, one could stop here and simply talk about these metrics louder and louder and how much it will take to invest in solar renewable plants like Boomtown to replace just one fossil fuel plant. Obviously, however, not every day in the year is January the 1st. While a solar-powered, presumably, Ameren is talking about phasing in wind-powered facilities as well as solar facilities. Presumably, it's talking about placing these assets in appropriate places. Presumably, Ameren is talking about a day when the solar power facilities are not operating in the red. I used the word presumably a lot, and that gets to the nub of the case. Ameren likes to claim that staff opposes all renewable projects. Not so, and the Commission's past case showed that. And staff does not oppose all renewable projects. Furthermore, staff does not oppose Ameren's aspirations to phase renewables into a balanced mix of resources, dispatchable and non-dispatchable, so long long as Ameren's proposal actually remediates the identified need at just and reasonable rates. So what's the problem here? Problem is that Ameren's telling us that while its game plan is to get us to Kansas City, Ameren has charted a course on a road map that goes to St. Louis without showing us how we're going to get turned around. The problem is that the road map shows that I-70 ends up in the wrong place if we go in the wrong direction. Now, Ameren is saying, well, all will be revealed, not to worry. The problem is that we, the staff, refuse to accept the presumption that something will change when it's forecast, when there's no basis in reason to say it's going to change, and focus. We insist that we focus on what we have here and on the roadmap that we've been given. And why would we possibly think that this thing will turn around? Stubborn fact, Ameren has now provided us with some updated analysis on the economics of the project that show a roughly 20% increase in cost. Now, that wasn't in the initial application. And that is a demonstration of how things change in the wrong direction. So, in conclusion, what do we propose here? Two things should happen. One, either the commission should reject Ameren's CCN outright and send Ameren back to the drawing board and put together something that shows us that we will, or at least shows us what assumptions can be made or what assumptions have to be made in order to make this thing work. Or, as one of our conditions for the granting of a CCN, the commission should order that a hold harmless agreement be attached to the CCN that shifts some of these risks back over to the shareholders. The basic argument here that we've heard from the proponents of this application is that we need to do something. We cannot stand where we are. We have to do something. What I've noticed is the definition of we. It appears that they would like us to think that this definition, or that the problem with this case focuses on the definition of need. Well, it does. It also focuses on the definition of we, and we should include the shareholders. If these risks are compelling, if we have to do something, then we all should be in the game together. And if the CCN is granted by this commission, the we should include the shareholders. And the solution should reach the shareholders in the form of a hold harmless agreement that shifts an equitable amount of these risks over to them. Again, I reiterate what I started with here. I heard here that all will be well if we just take care of matters down the line with a prudence review. A prudence review in the future is not a license to be reckless and imprudent now. It is not a license not to do due diligence now. And if these risks are so great that we have to jump out into territory that in the basis of the past and the way the commission has operated in the past, we would never do. But if we are in that position now where we must jump, must do something, then the risks of non-performance, the risks of a problem, should be fairly and equitably shared by all. That would be the definition of safe and adequate service at just and reasonable rates. Thank you very much.
All right, thank you, Mr. Graham. Commissioner Root, do you have any questions? All right. Do any of the other commissioners have questions?
Judge, I got a few questions. This is Commissioner Holzman.
All right, go ahead, Commissioner.
Thank you. What would you say is the natural life of this system? How long do you think it would be in operation before it needs to be decommissioned?
Commissioner, I'm going to look over at the person sitting beside me here and ask him, as I say this, to raise his hand if I'm wrong. I think the answer is that the projection is approximately 30 years as an operational life. That's the estimate.
30 years?
30 years.
And what value of solar study did you use to determine peak load shaving off-system sales, diversion, the true value of solar. Can you tell me what source you use to determine that value?
Commissioner, I'm sorry I can't tell you a blessed thing about that. I'm going to have to defer to my witnesses in the course of the testimony. I am sorry.
Okay, thank you. And has staff taken a look at, we know storage is an ever-evolving technology. As storage evolves, have they looked at what storage could do for capacity in the future, since this is a 30-year system?
Jay? Did you hear the question? Storage.
Your Honor, I certainly would like Commissioner Holzman to get answers to his questions, but I don't think witnesses can provide those answers as part of the opening statement at this point.
Right.
Okay.
Mr. Graham is looking
Fair
at
enough.
his.
I'll hold them.
Okay. All right. Any other questions?
Thank you, Judge. No more questions.
Thank you.
All right. Thank you, Mr. Graham. All right. Before we get into witness testimony, there is a couple of matters that I'd like to take care of. Mr. Lowry, I touched on this last week in an email or two to all the parties, but the testimony of Mr. Lansford, it's your position that that testimony is not, well, I don't want to put words into your mouth, but you're not relevant, and therefore you are not offering that testimony into evidence.
That's correct. We made a filing, actually probably a couple months ago at least, that indicated that that we would not be offering that testimony, that notice we're not seeking the relief related to use of a tax equity partner in this case. We're not seeking any waivers because, as our rebuttal testimony explains, we don't know at this moment what kind of tax strategy we will ultimately use for this project if it's approved. If we did ultimately need to use a tax equity partner, we've committed in that testimony. We'll come back to the commission for whatever approval we need. As we sit here today, I think we believe it's more likely we won't, and therefore we wouldn't need any further permission. But Mr. Lansford testified about a situation that just doesn't exist anymore. And there's just evolution has happened in this docket because of the Inflation Reduction Act that was passed after the docket was filed, and therefore we don't, it's not relevant, but we're also not asking for the relief that he was essentially supporting or testifying about in that testimony. We're not asking for that any longer.
Okay. But when I reviewed your witness, Lindsay Forsberg's testimony, to me it looks like it's still up in the air as to what type of financing, what type of tax credits you plan to use, and I just feel like it would be useful to the commission to have that testimony of Mr. Lansford, where he does get into the ITC. What?
Yeah, I think he gets into the tax equity if PTCs are used. I get the reason that we don't believe it is. I mean, tribunals like the commission are typically going to decide things that they need to decide and they've been asked to decide, and we are not asking them to decide anything about the financing or anything like that. And you're right, Ms. Forsberg's testimony would indicate a final decision hasn't been made. But if we need further relief from the commission in order to use the PTCs and tax equity, we will have to come back and we will file an appropriate application, but we're not asking for that now, which is why we didn't think the commission needs to decide something, A, that we're not asking it to decide, and B, that it may never need to decide.
Okay. So you would object to that testimony coming into evidence?
I guess I don't intend to offer it, and we didn't intend to tender Mr. Lansford as a witness. None of the parties have asked for that to happen, despite us indicating 2 or 3 months ago we didn't intend to offer it. Obviously, subject to whatever commission orders that would be made, we'll evaluate and, you know, deal with those orders. But we don't intend to offer it, and again, I just don't think the commission's being asked to decide anything that testimony pertains to.
But I'm, but I'm not sure if you're answering the question that I'm posing, and that is, if the commission, on its own motion, would admit that as an exhibit, would you have an objection to that?
That imply that Mr. Lansford would have to appear and testify?
Well,
or
that would be question number 2.
Would it be possible for me to consult with my client about this, and rather than
Sure,
answering
sure.
the question on the fly?
We don't have to make a
at
decision
this
on
moment?
that. No.
Okay, we will
So,
do that.
All right. Now, let me ask you this, though. Which of your witnesses would be the best witness to answer questions about the investment tax credit versus the production tax credit?
I think that either Ms. Forsberg or Mr. Wills are pretty well conversed in both of those and could answer questions.
Okay. And which witness would be best if the commission has questions about the renewable energy credits?
I would say probably Mr. Wills.
Okay. All right. Mr. Graham, similar question. Which of your witnesses would be in the best position to answer questions about the public counsel's suggestion that there be a 50-50 cost and risk sharing mechanism between shareholders and ratepayers?
Cedric Coonigan, Your Honor. Cedric Coonigan, Your Honor.
All right, thank you. And then which witness as far as answering questions about the renewable energy credits?
The same, Your Honor.
All right.
Cedric Coonigan.
All right, thank you. Now, before we get to Ameren's first witness, I would suggest we take a break and reconvene roughly 10:30. All right, let's go off the record. Let's go back on the record. All right, Mr. Lowry, call your first witness.
Your Honor, we call Ajay Arora to the stand.
All right, Mr. Aurora, good morning.
Morning.
Would you raise your right hand to be sworn in, please? Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Mr. Lowry.
Would you please state your name for the record?
My name is Ajay Arora.
Could you spell that name, please?
It's A-J-A-Y, last name A-R-O-R-A.
Mr. Arora, did you cause to be prepared for filing in this docket direct testimony and sir rebuttal testimony that has been marked as Exhibit 1 HC 1P and 2 HC 2P respectively?
I did.
Do you have any corrections to that testimony?
I do, and it relates to my sir rebuttal testimony, page 34. I had provided some alternative language regarding as-built drawings that all the parties had worked through and had been proposed in the Huckfin case. And the commissioners had found that some of that language was inconsistent, and so we had corrected it in the Huckfin case, and we need to do so in the Boomtown case as well, in my sir rebuttal testimony.
Did you prepare an exhibit that reflects the corrected language that you would like to replace in your sir rebuttal testimony based on that inconsistency the commission identified?
I did.
Your Honor, can I get an exhibit mark? I think it's 14. Yeah, shoot. They're for the commissioners and you, Judge, and we have copies for the parties as well. Mr. Arora, I've handed you what's been marked as Exhibit 14. Would ask you if that's the document you prepared reflecting the correction.
It is. Thank you.
What lines and page numbers should the text on Exhibit 14 replace in your sir rebuttal testimony?
It's page 34, lines 5 to 12.
For that, Your Honor, I'll offer Exhibit 14 rather than Mr. Arora having to read a few sentences into the record to reflect the replacement of lines 5 to 12 of his sir rebuttal testimony.
All right. Is there any objection to the admission of Exhibit 14?
I haven't seen it.
Oh, I apologize. I thought we handed it out. My apologies.
No objection.
Just for the record, Mr. Arora, is the language that you propose to substitute identical to the language that was recently submitted in the 0244 docket, with the exception of the acronym EDF has been changed to Invenergy to reflect that Invenergy is the developer on the Boomtown project?
It is.
All right, so if there are no objections, hearing none, Exhibit 14 is admitted.
Mr. Arora, if I were to pose the questions in both your direct and sir rebuttal testimonies that are asked there, would you give the same answers today, with the exception, obviously, of the correction you just made in your sir rebuttal testimony?
I would, yes.
Are those testimonies, to the best of your knowledge and belief, true and accurate?
They are.
Thank you, Mr. Aurora. I have no further questions, Your Honor, and I tender Mr. Aurora for cross-examination.
All right. If I have this correct, if I have the order correct, then it would be Ms. Pleshia first. No questions. All right, no questions. And then Mr. Opitz on behalf of Walmart.
No, thank you, Your Honor.
All right. Mr. Thompson.
No questions, Your Honor.
All right. And Ms. Greenwald.
No questions, Your Honor.
Mr. Williams.
Thank you. Good morning, Mr. Aurora.
Good morning.
Are you familiar with ancillary services in the MISO?
I am.
Will Boomtown provide the same ancillary services that Ameren, Missouri's thermal units such as Callaway or Rush Island or Labadee or Sioux provide?
No, but we have a need for energy as well.
What ancillary services will Boomtown not be able to provide that those other units will?
Ramping, for example, potentially voltage support.
What about frequency support?
Combined with batteries, they could potentially provide frequency support, but standalone, not as much.
Is it physically inherent in the Boomtown solar array that it cannot provide these services, or is there some other reason why it won't?
That's a technical question.
Well, if you don't know, that's fine.
Yeah, I don't know.
Do you know who does, who will be a witness?
Certainly one of our engineering witnesses could probably answer that question.
Rush Island's still dispatchable currently, isn't it?
It's dispatchable as a system resource, so it's really there for emergency purposes.
What kind of emergency purposes is it there for?
It's when MISO may be, short during certain times of the year, which it looks like there'll be more and more in the future. Rush Island can then provide system support services.
Is Ameren, Missouri under some obligation to, in the near future, cease operating Rush Island altogether?
Yes, we plan to retire Rush Island before 2025 as a result of a court order.
Is that true of any of your other thermal generating units, Sioux, Labadee, Callaway?
We expect to retire Sioux, which is really reaching the end of its useful life by 2030.
Is it because of some court obligation, or it's operational is the basis for that planned retirement, correct?
You mean Sioux?
Yes.
Yes. It's reaching end of life. That's the reason for the retirement.
And when you say reaching end of life, is that Ameren, Missouri's determination that it's not worth the whatever cost it might take to rehabilitate or continue operating that unit?
It's a combination. Every unit plant has an expected life. After a while, there are safety concerns, and then there are operational concerns and economic concerns. Things like high energy piping can get to a level where it's not safe to operate anymore. So all those factors are taken into a determination of when we might retire a generation unit.
Well, in the past, you've done things like add scrubbers to the unit to continue operating it, have you not?
That's right, and that was based on the expectation of its useful life. The scrubbers were added, I believe, in 2009, when there was plenty of useful life left at Sioux.
Is there any particular factor that's determinative of your planned retirement date for Sue?
It's essentially, like I said, safety related as well as operational concerns, as well as the fact that the equipment is aging and spending that much money on a plant that is essentially getting old, reaching end of life, and potentially may have safety related issues is not really in the best interest of our customers.
Are you familiar with what kind of atypical, I guess I would call it, fuel and purchase power cost Ameren, Missouri incurred in MISO during February of 2021?
Just slightly.
Do you have a number for that?
I do not.
Do you know if it was hundreds of millions or tens of millions? Or
Don't recall.
The Ameren, Missouri's, the Boomtown Solar Project, initially it will create direct current, correct?
Correct.
And then that's what, inverted to create alternating current, correct?
That's correct.
And then that alternating current needs to be synchronized in terms of the frequency with the grid, correct?
Correct.
Does the cost that Ameren, Missouri's put in its application for its estimate of the Boomtown costs include that synchronization?
It does, yes.
Is that part of the interconnection agreement requirement?
It's part of the interconnection agreement. It's also part of the bill transfer agreement. So the whole idea is that the plant would be fully tested, commissioned, and then synchronized to the grid. Mainly to provide energy that we need by 2028.
No further questions, thank you.
Thank you.
All right, Mr. Graham, do you have questions on behalf of the staff?
Clarification here. Is the location of the Boomtown facility, do you anticipate, or does Ameren anticipate that that location will be considered a, quote, energy community, close quote, with respect to the Inflation Reduction Act?
We do, yes. And the other benefit is the energy prices are really high there, so it should benefit our customers also in the future from that perspective.
You anticipate that the Boomtown then will be in an energy community?
We do, yes.
And it's being in the energy community is one of the suppositions or assumptions that you rely on for recommending this project?
The real reason for recommending it is that we have a defined energy need.
I understand that that's another reason. Does the fact or the supposition, since you brought it up, since Ameren brought it up, does the supposition that Boomtown will be considered within an energy community, as that expression is used in the Inflation Reduction Act, is that one of the reasons that you are advancing this project to the Commission for approval?
That just helps the affordability. The project is required for meeting our energy needs.
I understand that, but the company has come before the Commission. The staff did not come before the Commission. The company has come before the Commission with a number of arguments. And one of those arguments is that this project should be approved because of its location and the advantage of that location, the financial advantage of that location with respect to the Inflation Reduction Act. Is that not true?
That is certainly beneficial for customers, absolutely.
Can you state within any reasonable degree of certainty that in the future, at a future time, the Boomtown facility will be within what is considered an energy community? Can you state that that will happen within reasonable certainty?
That's certainly our expectation, yes.
That is your expectation. Can you state it within reasonable certainty that that will happen?
Yes, I can.
All right. What will have to happen? What will have to change? Is that answer based on any other assumptions?
No.
Nothing will have to change?
No, we have essentially looked at the communities nearby, and we expect it'll qualify.
All right, thank you. Now, if that's the case, then my next question is, do you know whether or not Boomtown will be eligible for the full amount of added tax benefit of those, of the relevant provisions in the IRA? Of the Inflation Reduction Act? I better define that one for our court reporter.
Yes, I expect it'll qualify for up to 40% tax credits, which really reduces the cost to customers for a resource we need for energy purposes.
Tell me, sir, which witness I should, if not you, ask about, well, this question, assuming Ameren enters into a tax equity partnership for Boomtown, what risks the tax equity partner will carry that will not recover their investment plus a return? Can you tell me who I should ask that? Maybe it's you.
Yeah, maybe it is me. Could you please
try it
restate
again.
the question?
Assuming Ameren enters a tax equity partnership for Boomtown, what risks will the tax equity partner carry that they will not recover their investment plus a return?
The tax equity agreement is structured such that it's a financing agreement essentially, so they do recover their return.
All right, thank you. That's all the questions I have of this witness.
Thank you.
Chairman Roop, any questions?
Good morning.
Good morning.
You'd stated that, you know, Ameren has an energy buffer, but you're going to need energy resources in the future. But following up on OPC's questioning, there's no ancillary benefits that you mentioned, ramping voltage supports frequency. Why did you choose to go with the solar instead of a new natural gas or some other option?
So essentially, Chairman, we need both. We need energy as well as capacity as well as ancillary services. The paradigm of planning has shifted. And the reason for that is renewables are the least cost resources for energy. And so as opposed to a historical paradigm where we would plan for capacity, we now need to separate energy, capacity, and ancillary services. Our energy needs are essentially best met with renewable energy. First of all, they're cost effective. Secondly, they mitigate a lot of risk. There's no fuel risk with renewables. There's the ability to hedge against any carbon emission pricing that may come out in the future. There's the possibility to hedge against investor expectations. There's the possibility to hedge against customer expectations. And at the end of the day, you know, solar resources as well as wind meet energy throughout the year. So that's meeting the energy requirements. Then for reliability purposes, we would install a combined cycle generator, which would not only provide capacity, but provide the ancillary benefits as well. And if it so happens that there's a buffer of energy, that's actually beneficial to customers because that money flows back to customers and reduces the cost for the transition. So pinpointing planning towards energy and capacity in the future to make use of the least cost renewables is what we need to shift to. And that's what this case is about. It's the start of that transition.
So the crux of going with this solar, other than another option, is anticipated concerns of the future as far as potential carbon tax, investor pressures for certain types of investment, shareholder viewpoints on green financing, kind of anticipating those pressures in the future? And is that a driving force for this?
The main driving force is we have a shortage of energy, and the implications
You
are
said
huge.
that with the main driving force, so let's table that for a side. But the main driver of energy, you can get energy from other places. So, because you said, you're separating energy capacity and ancillary services, but a lot of the reasons you gave was anticipated pressures from potential carbon taxes, potential pressures that have not yet realized. So separating the energy piece, is that the driving force for this particular project?
The main driving force is renewables are the least cost way to meet energy needs. All of the other aspects are a hedge against potential risks that may manifest themselves in the future. But to meet energy needs, renewables are the least cost resource.
Okay, so this is the first proposal, I guess, before us since Ameren's filed its preferred resource plan. Do you believe that if the commission were to grant this CCN, that it is implicitly approving Ameren's preferred resource plan?
That depends on how the commission issues the order, but I think we would like the commission to consider our need to transition away from coal-fired generation that is reaching end of life. And what we have proposed is a reliable and affordable plan, and that's what the IRP does. So yes, I do think it's valuable for us to know what the commission feels about the transition.
Great, thank you. That's all I had, Judge.
All right. Thank you, Chairman. Any questions from the other commissioners?
Judge, this is Commissioner Holzman. I have a couple questions.
Go ahead.
Thank you. Thank you for your testimony today. Back to the discussion of the value of solar study. Has the company, can you cite the study the company is using to take a look at peak load shaving and off-system sales diversion and other value of solar that is embedded in the technology itself? You said that solar was least, or renewables were least cost option. Can you talk a little bit about how you arrived at that conclusion?
Certainly. In the direct testimony of Matt Michaels, we included a chart that looks at the levelized cost of energy. That's a calculation we do in every integrated resource plan, and it looks at the overall cost, capital as well as operational cost for a resource over its life divided by the production of energy. And as we have looked at those charts historically, renewables have always been least cost as compared to other resources for energy purposes.
How about the storage aspect when it comes to capacity? Can you give us an idea of what you're seeing in terms of if this facility would ever be paired with storage to firm up its production?
It could certainly be paired up with storage, but the benefit of storage now with the Inflation Reduction Act is even standalone storage gets up to 40% tax credit. So it could be paired at the location with Boomtown, or we could put storage anywhere else on the grid to provide reliability. So there's certainly a myriad of ways to firm up energy from renewables, especially with the IRA, the Inflation Reduction Act, providing up to 40% tax credits for storage, standalone.
Now, this project's being built in Illinois. Do you have plans for Missouri assets as well for renewables?
We do, and the Huckfin project that was, that we have a stipulation, an agreement on with other parties, that's being built in Missouri. It's 200 megawatts. It's the largest solar plant that the company would own in Missouri. And Boomtown is in Illinois. And the idea is, as we think about renewables replacing coal-fired generation, it's beneficial to have a geographically dispersed portfolio of assets that we can operate to ensure reliability.
Okay, thank you. Thank you, Judge. No more questions.
All right. Yes, Chairman Root, you have another question.
Yeah, thank you, sorry. Commissioner Holden had mentioned something that jogged my memory. Is there any, I know you mentioned the IRA tax credits and stuff, is there, since this is being built in Illinois, and I know Illinois' legislature has passed some investment subsidies for renewable energy in the past, is Ameren attempting to gain or get any type of subsidies from the state of Illinois, for this project since it is located in Illinois?
Yeah, so, the main benefits in Illinois are we'll get up to 40% tax credits from the federal level as well. The energy prices in Illinois are meaningfully higher than Missouri, so that does benefit Missouri customers. In terms of the local taxes, that's still being negotiated with the local county. So we'll certainly do what's best for our customers there. But the fact that we get up to 40% federal tax credits and then the locational marginal prices are meaningfully higher, that certainly bodes well for this project, along with the aspect of providing a hedge because it's geographically dispersed.
But to your knowledge, is there any state subsidies offered through the state of Illinois that you're applying for or will be benefiting from this project?
Not that I'm aware of, no.
Thank you.
All right, thank you, Chairman. Any other questions from the commissioners? All right, hearing none. Mr. Aurora, I do have some questions myself. You're familiar, I would assume, with the term force majeure?
I am.
Okay. If during construction of this project, will Ameren carry insurance to cover force majeure events?
I don't know if we'll carry insurance to cover force majeure. That's certainly something we can look into, because it is an act of God, and it'll have to be something we consider. We haven't decided on that yet.
And then once operational, would there be insurance for such events?
Yes, once operational, we would absolutely have operational insurance.
Would that insurance, if you can answer this, would that insurance, besides covering the complete loss of generation, would it cover reduction of generation and reduced revenues?
If it's because of an outage that's extended, potentially, if it's due to weather-related aspects, I don't think the insurance would cover that.
Okay. Once the Boomtown Solar Project is up and operational, who will be responsible for the operation and maintenance cost? Will that be the subscribers? Will that be the ratepayers? Some combination?
So Ameren, Missouri will operate and maintain the plant. In terms of how that cost is allocated, if we have the Renewable Solutions Program, subscribers will certainly pay a portion of it. Otherwise, it will be all our customers.
So are you saying during the first the subscription program is a 15-year program, correct?
Correct.
And so are you saying during the first 15 years, the subscribers would
pay a portion of all the cost of the project, including operations and maintenance.
But the ratepayers would be responsible for some of those costs?
That's right.
Or a portion of those costs?
That's right.
And then are you saying from years 15 through 30, it would be completely covered by the ratepayers?
That's right. If we don't extend the sale of the asset for the renewable solutions, it would be completely be covered by all our customers.
Are you saying if you don't have another 15-year subscription program?
Correct. I mean, it's certainly possible we might renew.
Okay. and I don't know if you need to refer to this, but in your SIR rebuttal testimony on page 35,
Okay.
you list an updated estimated cost for the project, correct?
I do.
What level of design is this updated estimated cost based on?
It's based on slightly more than 30%, which essentially has identified all the major equipment, as well as for a majority of the other categories, the units for each equipment.
What factors can further impact those estimated costs?
At this point, since we expect to give clearance for construction if the project is approved by the commission in a few months, it would really be maybe some market changes around commodities.
Okay. And then what time frame does Ameren expect to finalize the project costs?
In a few months. So certainly by the end of May, the project costs would be finalized. And then it'd just be subject to, based on the agreement, to force majeure and those kind of risks.
Can you explain for the commissioners the difference between nameplate capacity and accredited capacity?
Certainly. So nameplate is essentially the size of the project, the capacity that it's rated for.
Is that like the maximum power it could generate if everything's going perfectly?
Correct.
Okay.
It is. Accredited capacity, as far as the Mid-Continent Independent System Operator is concerned, they calculate the capacity value at times of peak during different seasons, and they assign a capacity value to it. That doesn't mean that the plant cannot generate more than that in that season. It just means that during those peak hours, it's expected to generate a certain amount, and that's the accredited value they provide.
In the company's preferred resource or preferred plan resource timeline, are the addition and retirement capacities nameplate capacity or accredited capacity?
The retirements are, well, they're both. It's mostly accredited, though, in the planning process, because that's what we have to account for with MISO.
Okay. In that timeline, it shows 700 megawatts of wind came online in 2021. I forget the name of that project.
It's High Prairie and Atchison. Those are nameplate.
High Prairie. And then in 2022, 827 megawatts for the Merrimack Energy Center was retired, correct?
Correct.
Okay. Does that mean that Ameren, Missouri is currently short of capacity of 127 megawatts until an additional 800 megawatts of solar is installed in 2025?
So now I understand the timeline you're talking about. Sorry. The Merrimack number is nameplate as well as accredited. The 700 megawatts of wind is nameplate, but not accredited. So MISO will give a smaller value for that. So the amount of capacity we may need once Merrimack retires, if for MISO purposes, would be more.
Okay, in that vein, nameplate versus accredited, are you familiar with Public Counsel's witness, Dr. Marks' figure 3 in his testimony that's labeled assumed MISO resource accreditation and seasonal impact?
Yeah, I'd have to look at it to refresh my memory.
It is in his rebuttal testimony. But I think I can ask my question without you having to actually refer to it. But in that testimony, he lists the assumed accreditation for each generating resource. And it lists, for example, it lists nuclear is 95% accredited, coal 90%, gas 90%, battery 87.5%, and then solar 35%, and wind 16.6%. Would you agree, assuming you find those figures reasonable, would you agree that MISO's accredited capacity for coal and gas, which is 90%, is higher than the accredited capacity for wind and solar resources?
I would, for capacity purposes, yes.
And again, we're talking about accredited capacity takes into account varying weather conditions, reasons why solar and wind might not be producing at their nameplate capacity, correct?
Correct, and I think that's the distinction I was drawing. When we use renewables, which are least cost for energy, we have to plan not only for capacity, but also for energy separately.
And the company's preferred plan replaces coal capacity with wind and solar capacity through 2023, correct? Did I say 2023? 2030.
That is correct.
Okay. So using those MISO assumed accreditation percentages, would you agree that replacing resources with a lower accredited capacity with a retired resource with a higher accredited capacity could create a significant capacity shortfall of approximately 2,200 megawatts?
Yeah, just on the math it would, but we are long capacity right now. And so that's why, in the IRP, we have planned not only for capacity needs, but also for energy needs. So the capacity need is eventually met by the combined cycle in 2031. Before that, we have energy needs and needs for an energy buffer, which is being provided by renewables.
So from your perspective, is the replacement of that capacity a need for Ameren?
The replacement of enough capacity to meet MISO needs and planning resources is a need. The replacement of energy to meet our customers' needs is also a need. So we have to meet both in order to have a reliable system and an affordable transition. Just because we have capacity length doesn't mean we'll have energy in all hours of the year. Mm-hmm. We have seen several times historically where that's proven to not be the case for a myriad of reasons: operational, permitting, fuel access. So that's why, as we think about the transition and the least cost transition, we have to not only plan for energy, but also for capacity separately.
So would approval of this CN mitigate the capacity shortfall that Public Counsel and staff claim will exist if the company retires its coal generating facilities?
So in the summer, when MISO is short, potentially as early as next year, I believe MISO provides a 45% accreditation for solar. So yes, it would absolutely meaningfully help there. Solar does generate throughout the year, including in the winter. And so it helps with the energy needs as well. But in the summer, it's 45% is my understanding.
Okay. To shift gears a little bit, Chairman Roop mentioned that this solar project will actually be located in Illinois, correct?
Correct.
And MISO's service area has 10 zones, correct?
I believe that is correct, yes.
Okay. This project, the Boomtown Solar Project, will be in Zone 4,
In Zone 4, yes.
but Ameren's service territory is largely in Zone 5, correct?
Correct.
So if actual solar panels are located in Zone 4, and there's a need, and it's in the public interest for customers in Zone 5, why didn't the company propose to build the project in Zone 5?
So it's not any different than how we manage our needs today. We have about 1,800 megawatts of peaking capacity in Illinois that is jointly dispatched through MISO to meet overall needs. With renewables, it's also important that we have geographical diversity. So while we'll likely have a majority of solar projects in Missouri, I do think for reliability purposes, because renewable generation is weather dependent, it's helpful to have projects elsewhere as well. And so that's why we want to have this sort of geographically diverse portfolio.
And I believe you discussed that in your pre-filed testimony, but could you touch on it for just a bit? Geographical diversity, where you have sources of renewable sources in different geographical locations, what's the benefit of that?
So, and so let's maybe think about solar and wind as well. Solar generates when wind typically doesn't, so they're complementary for the most part. It could also be the case that, if there is a wind resource in one location, there may not be a wind resource in another geographical location. So by having a diverse resource, you essentially have generation at any given point of time. And the same thing could happen with solar. There could be cloud cover in Missouri, where we have a majority of our solar plants, but they may not be in Illinois or anywhere else where we site solar. And as long as all that energy can freely flow, which it can in MISO, it does ensure greater reliability than having localized solar all in one place.
Because the actual location of the panels is in Illinois, does Ameren have to, or has it gone through the Illinois Commerce Commission to get approval for the project?
Ameren does not need to go through the Illinois Commerce Commission for approval of this project, and we haven't.
Okay. In the company's preferred plan resource timeline, in 2042, the company plans to install 1,200 megawatts of clean dispatchable resource. What resources consist of clean dispatchable resources?
So potentially, based on the technologies today, potentially 3 or 4 of them. It could be small modular nuclear, which, there's a couple of projects in the United States that are proposed to be constructed. It could be combined cycle generation with hydrogen and or carbon capture. It could be long duration battery storage. And it could be any other means of storage as well.
Does MISO state any accredited capacity for those types of resources?
For nuclear, as you pointed out, it's about 95%. For combined cycle, I expect it to be about the same. For battery storage, I think it depends on as they test more and the duration.
The clean dispatchable resources, are they expected to be online by 2031?
By 2031, we have the combined cycle generation that would expect it to be online. And it's certainly possible that, we might be able to blend hydrogen with that. it is cleaner than coal because of carbon emissions being lower.
In your sir rebuttal testimony, if you want to refer to that, page 25.
Okay.
You state that the Boomtown Solar project was one of 4 viable projects as candidates considered by the company. What were the other 3 viable projects, and were they considered in the company's preferred resource plan? And if any of that information is confidential, we'll address that.
Okay. So one of them is Huck Finn, which we've already talked about. There's 2 more that is confidential. There's one in Missouri and one in Illinois.
Okay. And were those projects considered in the preferred resource plan?
Essentially, the preferred resource plan figures out how much we need, and then we go out for a request for proposals to see what's available. And then there's a loop. So I'd say in this case, the request for proposals was pretty close to when we filed. So yes, I mean, our pipeline of projects did feed into our 2022 preferred resource plan.
Are you familiar with the term decisional prudence?
Just a little bit. I'm not a lawyer.
Okay. I was curious how you would define, in your non-lawyer opinion, how would you define decisional prudence?
If a resource is needed to meet the energy needs and or capacity needs, and ensures our obligation of meeting reliability and affordability for our customers, I would say it's decisionally prudent in my non-lawyer view of things.
Do you believe that the commission should make a decisional prudence decision on the CCN and the Renewable Solutions Program in this case or in a general rate case?
I think we certainly have the ability to do so in a rate case for sure. I think it is helpful if they can determine, if a need exists in this case as well.
Okay. And then there was mention of it, I believe, in the opening statements, but the estimated project costs have been increased in this project. With those increased costs, would you still consider this project economically feasible?
I would, and let me tell you why. First of all, like I said, there is a clear need. Secondly, since those costs have gone up, a couple of things have happened. We have gained another 10% on the federal tax credits because of the Inflation Reduction Act. So that mitigates a lot of the cost. I will also say that in the last year, energy prices have dramatically increased, And, given all that, the hedge that any generation provides that is implemented in the near term is certainly valuable to customers. So there's a clear defined energy needs, there's the benefit of the federal tax credits, and there's a clear hedge against spiking energy prices in the near term.
All right, thank you. Thank you for answering my questions.
Thank you.
I'll give the parties an opportunity to recross the witness. So, Ms. Pleshia, do you have any questions? All right. Mr. Opitz? Mr. Thompson?
No questions, Your Honor.
Ms. Greenwald? Mr. Williams?
Yes, thank you. Mr. Aurora, do you recall you responded to Chairman Roop that Ameren, Missouri separates capacity energy and ancillary services whenever it's reviewing need?
I think that's what we need to do, yes. And that's what we did in this IRP, the 2022 preferred plan.
Do you capture synergies there may be whenever some asset might fulfill more than one of those buckets?
Absolutely we do, yes.
How do you do that if you're looking at them each independently?
Because, you know, as opposed to the outdated historical view of just looking at capacity, we now look at both. And so to the extent one resource can provide energy benefits as well as capacity benefits, we would give value to it in both areas.
So did you do that with regard to, say, combined cycle, given the experiences that have occurred in SPP and MISO in the past 2 years?
We did. We actually did a reliability study using a consultant, Astrape, and they looked at the benefit that the combined cycle would bring in once the Sioux Energy Center retires. And that's how we placed the combined cycle in that year. So we did an in-depth reliability analysis to ensure that the plan that the IRP has laid out not only meets energy needs, but also meets reliability needs. So the combined cycle absolutely provided that benefit.
It wouldn't provide benefit earlier?
So there's various reasons why we need a mix of resources. Like I said, the most cost-effective way to meet energy needs is through renewables. The most cost-effective way to meet reliability needs is through a combined cycle. When you have both, we essentially are creating what we have leaned on historically for decades and decades, and that's a long buffer on both energy and capacity. And that's what helps us meet our obligations to our customers, ensuring reliability as well as affordability.
No further questions. Thank you.
Thank you.
All right. Mr. Graham, do you have further questions?
Yes, sir. Directing your attention back to the judge's question about what your definition of decisional prudence was. Could you restate that for me? And this isn't a test of whether I mean, if you don't state it the same way, that's not my point. Just tell me what you mean by that.
So if we have a resource that meets our obligation to meet the energy needs and our capacity needs, or ultimately ensure that we are reliably and affordably able to serve our customers, if a resource is needed for that, I would deem it prudent.
Okay. Would you accept this amendment at just and reasonable rates?
Objection to the extent it calls for this witness to draw a legal conclusion about what just and reasonable means.
Sustained.
Do you think that should be done in a just manner? Just to ratepayers?
Same objection. He's asking the witness to opine on what the legal standard ought to be.
I agree. I agree. Sustained.
Your Honor, I'd like to make an offer of proof.
Go ahead.
I think the witness will accept that as an amendment to his personal definition of just and of prudence. And the question that was placed to him, I believe, by the bench was what his own definition was. And I'm asking him whether he will accept my amendment as an amendment to his personal definition. I am expressly not asking the witness for a legal answer. I'm asking him for his own opinion on the definition of decisional prudence and whether he will accept that as an amendment to his personal definition.
Judge, I'm going to lodge the same objection. I'll be perfectly honest. I didn't object to your question because you asked it, but that doesn't mean that the question didn't call for a legal conclusion. And I don't think that this is a proper level of inquiry for Mr. Aurora.
I think that the counsel has just admitted he opened the door. He said he wanted to object, but he deferred to the bench. He opened the door.
Right, but there was a difference between what my question was and what you're asking right now. So I'm going to sustain the objection and move on, Counselor.
Thank you. Near the beginning of the questions to you from the bench, you spoke about force majeure. I don't know that the court reporter knows how to spell that, but and I'm not sure I do either, that Majure is Majure?
That's right.
Okay. What is your understanding of that kind of insurance?
It's insurance against an act of God.
Okay. And is that a kind of, I didn't understand your answer. Is that part of the project? Does Ameren anticipate obtaining that kind of insurance?
We'll certainly look at it right now. It's not insurance that's generally readily available, so it can be costly because, again, it is to protect against an act of God. But, it is something we'll certainly consider.
This is a solar-powered facility that counts on the sun. Is that right?
That's right.
Okay. In some of the questions, in response to one of the questions, I think that you said this project, the entire project is cost-effective?
Yes, I believe so, yes.
Actually,
Okay.
I think it
I
is.
believe economically feasible was the question.
And was the answer that in your answer, did you use the expression cost-effective?
I use that for renewables in general.
Because you're not stating that the Boomtown project is cost-effective, correct?
I believe the Boomtown project is needed to meet our energy needs and is therefore cost-effective by definition.
Okay, you're not stating that the revenues over the operational life of this project, that the revenues will cover its costs, correct?
No, if a project is needed to meet energy needs, it's by definition cost-effective, as long as it's at market
At the
conditions.
beginning of your answer, I heard the word no. Did you mean that this project, the Boomtown project, is not cost-effective in that its revenue will not meet its costs?
It could or could not. The projection is maybe it doesn't under some circumstances.
I'll accept that answer, and that's all the questions I have.
All right, Mr. Lowry, do you have redirect?
I do, Your Honor. And I'm probably going to jump around because there was quite a bit across, so I'll try to be as organized as I can, but I may just go in reverse order for the most part. Mr. Williams asked you some questions about, I think he asked you a question about more or less why not put in a combined cycle plant earlier. Do you recall that?
I do.
How is the company planning to meet its capacity needs as distinguished from energy and these other needs that you said you separate between now and 2031?
We have an existing portfolio of coal-fired generation that meets our required capacity needs. And the benefit of installing renewables while that portfolio exists is that we can learn how to operate a geographically diverse portfolio of renewables. We eventually get to a capacity shortage in the summer in 2031, and that's when the combined cycle would be available to meet reliability needs. It can also produce energy, but that's only beneficial for customers because it reduces the cost of the entire transition.
And why in 2031 does that capacity need arise?
That's because we retired the Sioux Energy Center before then.
Is there another retirement that happens then too?
There's the Venice gas-fired generation that happens at that time as well.
How many megawatts is that?
I think it's about 540 or 550 maybe.
What need are you trying to address in the interim?
In the interim, we are addressing the very real energy needs. And just under normal conditions, we expect to have an energy need potentially by 2028. But under adverse conditions, we could have it as early as 2026. And this is pretty dramatic because we have gone from a portfolio that had abundance of energy that protected our customers from various adverse conditions in the market to having an actual shortage. All this while the MISO market that we operate in is also short. So it is a pretty concerning state of affairs from an energy perspective. And Boomtown is just one of the resources we will need to fulfill that.
I think Judge Sire asked you, I think it was Judge Sire asked you some questions about maybe could you have a clean resource by 2031 instead of 2042 or something like that? Do you remember that?
I do.
I believe, well, let me just ask you, has the company accounted for, or is the company accounting for in some way the possibility that hydrogen or something else might be available earlier than 2042 and therefore could be used in the combined cycle you're putting in 2031?
Yeah, as we're looking at designing the combined cycle in 2031, we are looking at existing technologies that can allow for a blending of hydrogen in the design itself. I don't think we can build a combined cycle before 2030. It does take time to design and construct it and also get all the approvals, whether there's a CCN or all the permitting. But we are looking at whether we can blend hydrogen in that plant and potentially maybe even capture carbon in the future, if possible.
The judge asked you questions about resources being in MISO Zone 4, which I think is essentially Illinois, versus MISO Zone 5. You remember that?
I do.
Do you have any concerns as, I guess, the executive in charge of making sure the system's reliable with having generation in Zone 4?
I don't. No, we have operated that way for decades.
And why is that? Why should the commission not be concerned?
Because MISO has a responsibility to ensure MISO-wide there's enough capacity, and we have an obligation to ensure enough capacity to meet all our needs. There is free flow between zones 4 and zone 5 from a transmission perspective.
Do you know whether Ameren, Missouri has benefited from having resources in Zone 5 versus Zone 4 over the last 10, 15 years?
Certainly we have, because the capacity prices have been pretty high recently.
In Zone 5 versus Zone 4?
In Zone 4 versus Zone 5.
I'm sorry, I had it backwards, Zone 4 versus 5?
Right.
I think you mentioned something about energy prices in 4 versus 5. I think you said they had been higher in 4. What's the basis for that statement?
Historically, energy prices in Illinois have always been higher than Missouri, and I think that's a function of just how the system operates.
Judge asked you some questions, I think, about retiring Merrimack and the capacity going away, and then the capacity that had been added, and I think there was some math going on about, additive capacity versus capacity taken away. Do you have an opinion about whether that's the issue that the company's trying to address with these renewable facilities?
No, the issue we're trying to address with the renewable facility is our energy shortage and the concern we have going from an abundantly long energy position to a short position. So eliminating all our buffer and actually being short, while MISO potentially may be short energy as well.
And you're addressing the capacity with the combined cycle?
That's right.
You were asked questions by the judge and I think by Mr. Graham, both about force majeure and insurance and so on. If Ameren, Missouri was building this plant directly itself, would the insurance that it carry be the same or different than when it's having a developer build it under a BTA?
I think it'd be the same.
Commissioner Roop asked you some questions, Chairman Roop now asked you some questions about potential tax incentives in Illinois. Do you remember that?
I do.
I'm assuming you're not the expert at the company that keeps track of and pays attention and et cetera to, see what all tax incentives and how you qualify for them. Is that fair?
That's fair.
But given your position, well, first of all, does the company have people that have their ear to the ground, so to speak, and are always paying attention to that?
We do, and we talk to the developers about that as well.
If there were incentives available in Illinois, are you pretty sure you'd know about it?
I'm pretty sure the people that are experts in that field would know about it and seek them.
I mean, would they, They would tell you about them, wouldn't they?
Yes.
Commissioner Holzman asked you some questions about storage, I believe, did he not?
He did.
Is the company going to have to make decisions over the next 3, 5, 7, 10 years about what storage to put in and where?
Yes, absolutely.
Is there any relationship between the company having a diverse portfolio of various renewables on the system and the ability to make good decisions about what storage to use later?
Certainly. I mean, the operational experience we get by operating renewables allows us to determine how much and where storage should be sited, so that we are not overbuilding or underbuilding. That operational experience is vital to make that decision. Otherwise, we are just, planning blindly and hoping for the best.
And Mr. Williams asked you some questions about, I think, suggesting that the solar facilities or renewables in general maybe either don't provide ancillary services or they don't as effectively provide them. Do you remember that?
I do.
From where do you expect to get the needed ancillary services from Ameren Missouri system perspective?
Before 2030, I expect to get them from our coal-fired generation. After 2030, I expect to get them from our coal-fired generation, our hydro generation, as well as the combined cycle. So before 2030, hydro and coal-fired. After that, and gas-fired, sorry. Hydro, coal-fired, gas-fired. After that, it's the same resources, including the new combined cycle.
Thank you, Mr. Aurora. That's all the questions I have, Judge.
All right. Thank you, Mr. Lowry. And Mr. Aurora, I believe that takes care of your testimony, so thank you for your testimony.
Thank you.
Mr. Lowry, would you like to offer the witness's pre-filed testimony as an exhibit?
I was just going to say, I think I forgot to offer the testimony. I would like to offer Exhibits 1 and 2, all of the versions.
Okay, so it'd be Exhibit 1HC, highly confidential, Exhibit 1 public, Exhibit 2 highly confidential, and Exhibit 2 public.
That's correct.
Are there any objections to that? Hearing none, Exhibits 1HC, 1P, 2HC, 2P are admitted.
And Judge, I think I did offer Exhibit 14, but if I didn't, I would like to offer that. It reflects the correction to Mr. Aurora's rebuttal testimony.
Yes, that has already been admitted. All right, Mr. Aurora, you can
Thank
step
you.
down. Okay, it is 11:45. Mr. Lowry, do you anticipate your next witness being able to complete his testimony before 12:30?
I'll be honest, I have absolutely no idea because it depends on it depends on my co-counsel's propensity to ask him questions or the bench as well.
Well, how about we take about a 5-minute break and let's start on his testimony and go up until we get to 12:30 and we'll break then. All right, so let's go off the record. Mr. Lowry, call your next witness.
I call Matt Michaels to the stand, Your Honor.
Good morning, Mr. Michaels. Raise your right hand to be sworn in, please. Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. Go ahead, Mr. Lowry.
Thank you. Mr. Michaels, would you please state and spell your name for the record?
It's Matthew Michaels, Matthew-Michels.
Mr. Michaels, have you caused to be prepared in this docket direct and rebuttal testimony that have been marked for identification as Exhibits 3 and 4 respectively?
Yes.
Do you have any corrections to that testimony?
No.
If I were to pose the questions in that testimony to you today, would your answers be the same?
Yes.
Is that testimony true and correct to the best of your knowledge and belief?
Yes.
Your Honor, with that, I offer Exhibits 3 and 4 into the record and tender Mr. Michaels for cross-examination.
Okay. Is there any objection to the admission of Exhibits 3 and 4? All right, seeing none, Exhibits 3 and 4 are admitted. All right. Ms. Plescia, do you have any cross-examination? Is she in here? Okay. Can you speak for her? Do you have any cross-examination? And I'm sorry, for the record, what's your name, sir? I see. Mr. Brubaker. You slept at a Holiday Inn Express last night, so.
We won't report him to the bar, Judge, for unauthorized practice of law.
All right, Mr. Opitz? No, thank you, Judge. All right. Mr. Thompson?
No, Your Honor.
And Ms. Greenwald? All right. Mr. Williams, do you have cross-examination?
Not at this time.
All right. And Mr. Graham? Sure. Mr. Graham, I'm going to ask you to low.
Get that over here right now, thank you. I'm all aflutter here. Is it Michaels?
Yes.
Yes, Mr. Michaels, and it's Matt Michaels. Are you familiar with, in the matter of Ameren, Missouri's 2020 utility resource filing? In EO 2021-0021, that's unfair with respect to the case number, I know, but do you have a familiarity with that case? And if you don't, we'll try it again.
Yes, I believe that was Ameren, Missouri's 2020 IRP.
And were you involved in that case?
Excuse me, Mr. Graham. I actually didn't have my own microphone turned on. Is your microphone turned on, Mr. Michaels?
Let me check. Is that on?
Yeah,
Is that
that's
okay?
better. So maybe just
I'll
speak a little
closer.
closer to the microphone. Yes. Go ahead, Mr. Graham.
Okay. Were you involved in that case?
Yes, I was.
What was your role?
I'm the director of corporate analysis, and so I have immediate responsibility for Ameren, Missouri's integrated resource planning.
And were you directly involved in the production of that document, that submission to the Public Service Commission?
Yes, I was.
This looks like this. Oh, these are. They're all copies. Okay. Is this your question? Or do you just want? What number are we, Your Honor, on staff's exhibits? Do you happen to know?
For Ameren's
I'm
exhibits?
sorry, for staff's exhibits.
Give me a sec. Give me just a second here.
I'm sorry, I should have that open myself. I think I've got it here. I think we're at 109. The next exhibit would be 110, I'm thinking.
That's correct.
Okay. Thank you for your indulgence, Your Honor. How do I do this? Do I approach the witness and thereby walk away from the microphone?
Yes, let's go ahead and have the court reporter mark your exhibit. And again, that'll be Exhibit 110. Well, I'm waiting to see if he's got copies for us up here.
Okay. I've handed to you an exhibit which is not marked in your hands, but the court reporter has marked another one that is the same as a copy of that as exhibit number 110. Are you familiar with that case?
Yes, yes, I am.
Sir, do you recognize the MPSC 0001 as a data request which the Missouri Public Service Commission's staff would have propounded upon Ameren in that case?
Yes,
Okay. And do you remember the questions and the responses that are directed or that are recorded on this document, which is exhibit number 110?
yes, I do.
And does this document fairly and accurately state those questions and the company's responses?
Yes.
Okay. I'm going to offer into evidence exhibit 110.
All right, and just so I understand what is shown in the exhibit, this is a data request, and it's a question, and the witness's answer, correct?
Well, it's Ameren's. May I verify with the witness, Your Honor?
Okay.
Yeah, this was a data request that was directed to the company. Have I said that right? To Ameren?
That's correct.
And was this Ameren's response to this data request?
This was Ameren, Missouri's response as prepared by myself.
Okay, so this was your response too, that you prepared for on behalf of the company?
That's correct.
Okay. With that clarification, I'm offering this exhibit 110.
All right. Are there any objections to the admission of Exhibit 110? No objection. You might want to turn on your microphone for that one.
No objection, Your Honor.
All right. Thank you, Mr. Lowry. Any other objections? All right. Hearing none, Exhibit 110 is admitted into evidence.
All right. Oh, I see. Mr. Michaels, is the energy produced by the Atchison Wind Farm included in the Ameren analysis of energy deficits in this case?
Yes, it is.
And Atchison Wind Farm is interconnected to SPP as opposed to MISO, is that correct?
That's correct.
And for the sake of the court reporter and anyone else that may need it, what is SPP?
It's the Southwest Power Pole.
Okay. And does Ameren, Missouri have a firm contract path to get the energy from SPP to MISO to serve its retail customers?
Not to my knowledge.
How long has the retirement of the Merrimack been planned?
I believe the decision was made in 2014, included in the 2014 IRP filed by Ameren, Missouri, and reflected in the depreciation study in the rate review case that was on file at that time.
Were you here for Mr. Aurora's testimony here earlier today?
Yes, I was.
Tell me if I'm wrong. Did he discuss that having capacity does not mean that you have energy to meet load in all hours?
Yes.
Okay. And did Ameren provide the commission with 8,760 hour energy production numbers from Boone County and 8,760 load from customers in this case?
Not to my knowledge. It was part of the reliability analysis that we did, but we didn't explicitly provide the hour by hour.
No more questions, Your Honor.
All right. Chairman Roop, do you have any questions?
Thank you, Judge. Hey, good afternoon. 3 minutes past noon. All right. Somewhere I read that Ameren had said that there was dispatchable resources that they have mothballed that could potentially be brought back online. And I think staff had asked what those were, but I don't know if they got a response. Do you have, can you clarify that or update that of what references, what you were referencing?
I don't recall the reference. Was there, can you give me some context?
No. I could,
and I'm not aware of any mothballed resources that were mothballed in anticipation of bringing them back online.
Okay. Well, if someone out there knows what I'm talking about, or remembers and can point me to where I saw that, I'd appreciate that. In your knowledge, I know staff is asking for like a hold harmless provision as a compromised position in here. Has Ameren, or else has the commission approved any? Have we approved any CCNs with a hold harmless provision in the past?
I'm not aware of any. I mean, I'm aware of the Empire case where they had a customer savings plan. I don't remember if that was part of a CCN filing.
Okay. All right, I'm going to try to find that, and then I'll be back at some point. So,
Okay.
But thank you. That's all I had, Judge.
All right. Do any other commissioners have questions?
No question, Judge. Thank you.
That was Commissioner Holzman. Question mark?
I believe it was, Judge.
Yes, that's correct.
All right. All right, I've got just a couple of questions. Mr. Michaels, you were in here earlier when I was asking questions of Mr. Aurora.
Yes.
I'll ask you the same questions about nameplate capacity versus accredited capacity. Would you agree that MISO's accredited capacity for coal and gas at 90% is higher than the accredited capacity for wind at 16.6% and solar at 35%?
I'm not sure about the numbers, but I believe they are higher, yes.
Would you agree that the company's preferred plan replaces coal capacity with solar and wind capacity through 2030?
Yes, to the extent that we have needs, mostly energy needs, yes.
In general, Ameren is retiring coal generating plants with and replacing them with renewable energy, wind and solar.
Right. While we have an energy need and
Right.
not yet a large capacity need, yes.
But would you agree, though, that because when we compare accredited capacities, we're replacing, or the plan, Ameren's plan is to replace quite a bit of accredited capacity in coal production, coal generation, with lower accredited capacity wind and solar?
Yeah, yes, it is important, though, to keep in mind that we're looking at the capacity position as a whole, and we went into the last few years being long capacity, so we don't necessarily have to replace all of it.
And is it your opinion that the Boomtown project addresses a need and would be in the best interest of the public?
Absolutely, it addresses a near-term energy need. It also has some capacity benefits that help to minimize the amount of additional capacity that is needed and is complementary to wind resources from an energy standpoint and firmed up by dispatchable capacity like the combined cycle that we have in our plan in 2031.
Okay. All right, those are all my questions. Yes, Chairman Roop has a follow-up question, I'll say.
I do. Been researching diligently up here. Actually, no, I have a phenomenal staff that knew where I was going and pointed me to the right direction. So what I was referencing was Sean Lang's rebuttal testimony. There was an August 17th presentation that Ameren made in regard to the retirement of Rush Island, where Ameren stated it was studying restarting the existing idled equipment for dual fuel capability at its Peon Creek Combustion Turbine Energy Center and installing dual fuel capability at the Audrain Energy Center. Do you know what I'm referencing?
Yes, I do, and those plants aren't mothballed. What we're talking about is adding oil-fired capability so that they can be more reliable in the winter than they are now.
Do you have an update on where you are with that?
We're still examining that. One of the things that we have to consider is how many hours we could run those units on oil, what the permit restrictions are, whether we would have to get a permit modification in order to add that oil back up and operate those units on oil, and then also the costs.
Okay, let's make sure, assuming you've done your due diligence, you've done everything, when is this, and if you move forward, that when would be the soonest that would be available online?
I believe, some of that could be online the winter of 25, 26. Okay. It would be done in stages.
That was it. Thank you. Thank you, Judge.
Okay. Ms. Fleschia, Mr. Brubaker was kind enough to answer in your stead that he thought that you would have no cross-examination questions for the witness, but I'll ask you whether you do have any cross-examination questions for the witness.
Well, thank you for asking me, and Mr. Brubaker was, as usual, correct.
Do you have any recross for this witness based on what you've heard other attorneys ask? I'm asking you, Ms. Fleschia.
I'm sorry, no questions.
Okay.
Thank you.
All right. Mr. Opitz, do you have any recross?
No, thank you, Judge.
Mr. Thompson?
No, thank you, Judge.
Ms. Greenwald? And Mr. Williams?
Just a few, I believe. Mr. Michaels, you recall when Chair Roop asked you about Audrain and Pinot Creek?
Yes.
What is currently the fuel source for those sites?
Natural gas.
And so what you're talking about is making them dual fuel capable so they could burn diesel as opposed to natural gas?
It would fuel oil.
Is there a difference between fuel oil and diesel?
I don't know.
My understanding from another case is it's number 2 diesel, but in any event, I don't know that that matters. There have been several questions about capacity, about nameplate capacity and credited capacity. Isn't it true that every generating unit, its actual available capacity changes over time?
I believe that's generally true.
So for example, a solar facility would have more capacity during daylight hours than at nighttime?
It would produce more. I don't know that the capacity necessarily changes. If the sun suddenly appeared, it could generate.
And that's what I want to get into, exactly what you mean by capacity in that sense. Is capacity what it's capable of producing at any given point in time, or is it what it's possible for it to produce at a given point in time, given the energy source?
It's the former. It's what it's capable of producing at any point in time.
What would you call what it's capable of producing, given the limitation on the energy source that's being converted to electricity?
I don't know that I have a term for that.
Thank you.
All right, Mr. Graham, do you have a recross?
Do you know what PINO stands for? P-E-N-O?
Mr. Graham.
That there are many interests. Do you know what PINO, P-E-N-O stands for as an acronym?
I don't. If you're talking about Pinot Creek, it's not an acronym.
So that, okay. Assuming that the Pinot, is that how, am I saying it right?
Yes.
Okay. Assuming that the Pinot Creek and Audrain units add dual fuel capability, the projected winter capacity deficit of Ameren, Missouri in the late 2020s would be reduced. Is that by this facility? In general, is that correct?
That's true. It's not clear how much, but we wouldn't do it if it wasn't going to provide some capacity benefit.
Okay. Thank you. No further questions.
All right. Mr. Lowry, Integrity Direct.
Just a few, Your Honor. Mr. Michaels, going back to the question that Mr. Graham just asked you and some of the questions that were asked, maybe it was by Chairman Roop about Pinot Creek and Audrain. Is Ameren, Missouri looking to make those dual fuel to provide energy or provide capacity primarily?
It would only be capacity because it would be very limited in terms of the hours that they could run.
Whether those are made dual fuel or not, do you have an opinion about whether that has any impact on the company's need for energy from solar facilities or wind facilities?
No, I wouldn't expect it to have any impact.
The judge asked you some questions, I think, about, retiring coal and replacing with renewables. Do you remember that?
Yes.
If you're looking at the big picture of the company's plans, would it be fair to say that Sioux and Venice go away 2030 or so, and they're really being replaced by the combined cycle plant?
I think that's fair.
Certainly from a capacity standpoint, is that accurate?
That's correct.
Is the driver to build the combined cycle to produce energy or to provide capacity?
Is to provide capacity and make sure that we have reliability when wind and solar resources aren't generating, or when their output changes dramatically. We need those flexible resources to respond.
The chairman asked you a question, I think, about whether you had any knowledge about other, I think he used the phrase hold harmless decisions that might have made in a CCN case for other utilities. You remember that?
Yes.
And the only one you came up with, and you weren't sure it was a CCN case, but you mentioned an Empire Customer Savings Plan case?
Correct.
Are there differences in your mind between the situation there and the situation we have here?
Absolutely. My understanding of the Empire case was that the driving purpose was to reduce energy costs to customers, and so that's the way it was being presented. In our case, we have an energy need for a resource, and more resources on top of Boomtown besides that, and then also later capacity resources. And with that capacity need, we're looking for the least cost way of meeting that need. That doesn't mean necessarily that it has to produce more revenue in the marketplace than it costs. In fact, it doesn't mean that at all. It just means that we have to provide that need or meet that need in a least cost way and subject to all the other requirements of integrated resource planning.
Is the company justifying the CCN request in this case on some kind of contention that it will, in fact, lower revenue requirement?
No.
Do you have an opinion about whether it will lower revenue requirement as compared to the alternative of essentially waiting and adding capacity at the moment a capacity need comes up?
Yes, absolutely. In fact, in both my direct and my rebuttal testimony, I showed the comparative economics on a present value revenue requirements basis of doing just that, of doing the renewable expansion that's represented on our preferred plan versus waiting and doing the bulk of the renewable additions in the late 2030s. And what that showed was that we would expect customers to save about $600 million or so.
Is that plan that is disadvantaged, according to your analysis, by about $600 million or so, effectively reflect the position that staff is taking on this, in this case?
That's my interpretation, yes.
And you've read all of staff's testimony, is that correct?
Yes.
Mr. Graham asked about whether the company had provided 760 hours of production information, I think it was, for, I don't know if it was for Boomtown or generally speaking. Do you remember that?
Yes.
Did the staff ask for it?
No.
Did the information in the Estropy analysis you discussed in your testimony get to that issue?
It does. A few years ago, we brought in Estropy to start helping us think about reliability needs more deeply. And so their model, Servum, which is used by multiple RTOs for just this kind of reliability analysis, looks at historical weather going back close to 40 years, impacts on load, resource mix, access to other resources in the MISO market. And so it looks at it on an hourly and sub-hourly basis in a probabilistic manner. And we use that as the basis for really honing in on what the reliability need was that really was one of the main pieces of justification for including the combined cycle in addition to capacity.
I'm going to break a cardinal rule that lawyers should probably never break, but I'm going to do it anyway. The Estropy information was also in the preferred resource plan submission that was made last June, is that right?
That's correct.
The company provided work papers for that preferred resource plan change, did it not?
That's correct.
Which would have included that kind of information, is that right?
That's right.
And staff had access to those?
Yes.
And Mr. Lowry, excuse me, how is that spelled?
ASTRAPE with a apostrophe, I believe.
Okay.
Accent mark probably is more correct.
Yes.
You were asked questions about whether the energy produced by the Atchison Energy Center is included in the energy positions that we provided, and you indicated it was, right?
Yes.
Why, let me ask it this way. What is the purpose of having the Atchison facility on Ameren, Missouri system?
The main purpose is to meet the renewable energy standard requirement.
And does getting RECs from Atchison, whether it's connected to MISO or not connected to MISO, meet the renewable energy standard credit in the same way regardless of how it's connected?
Yes, it does, including the 1.25 multiplier for in-state resources.
And the last thing I think you were asking about, I was going to ask you about, is this DR number 110 from the IRP docket in 2020. I think it's been admitted as Exhibit 110. Do you recall that?
Yes.
Do you have an opinion about whether the company should be striving to meet its energy needs or its customers' energy needs, whether or not there's some below minimal standard in the law somewhere that says what it has to do?
Yes, absolutely. It's important to remember that when we're doing resource planning, things like planning reserve margins are minimum requirements. And so one of the things that we have to be mindful of is risks that we're not going to be able to meet those minimum requirements. So you think about things that could challenge the need for energy or the need for capacity. They include things like changes in load, which might be driven by electrification. It might be driven by not seeing the penetration of distributed energy resources that we bake into our load forecasts. On the resource side, it could be environmental regulations that restrict the operation of power plants. It could be maybe the sudden need or maybe a catastrophic loss of a generator. So we have to think about all of those things when we're doing our planning, and that's why it's important, as Mr. Aurora was pointing out, we have a buffer for both energy and capacity as a hedge against those risks and a hedge against the market in general.
What has Ameren, Missouri's energy and capacity position looked like over the last decade or two, if you know?
We've been long capacity as much as, I want to say 2,500 megawatts, certainly 2,000. And we've also been long energy at times over 10 million megawatts a year, or megawatt hours a year.
And I'm assuming you're not aware of a legal requirement during those periods to have been that long in energy and capacity?
No.
Was the company, to your knowledge, criticized by the staff for being that long during those periods?
I don't recall any criticism of that nature.
Do you have an opinion about how that has impacted the company's customers over the last decade or two?
Objection, that's just vague and overtly calls for speculation and conjecture.
I asked him if he had an opinion about it. I think he either does or he doesn't.
I'll sustain the objection.
I don't have any further questions, Judge.
All right. Mr. Lowry, in one of your questions, you referred to RECs, and I know what that refers to, but could you clarify that for the court reporter?
I can. Renewable Energy Credits. REX is an acronym for that.
Okay. All right. Mr. Michaels, thank you for your testimony.
Thank you.
You may step down. And I think we're at a point where we'll break for lunch. So we'll try to start back at 1:30, and we'll go off the record. go back on the record. Mr. Lowry, call your next witness.
Judge, if you don't mind, maybe before we do that, I wanted to address your question earlier about Mr. Lansford's testimony and him appearing. So we visited about it, and I'd like to make this proposal. If the commissioners could ask the questions, and you ask your questions, you know, probably of Ms. Forsberg or Mr. Wills this afternoon, and if you don't feel like you've gotten the information that you need, we certainly will make Mr. Lansford available, and I think we would prefer that on Wednesday and by WebEx just because of his other responsibilities and not the expectation. But if maybe we could just delay the final decision on that until our witnesses are done and we can deal with it at that point, if that's acceptable to the bench.
Right, that's perfectly reasonable.
Okay, thank you.
Your Honor, for staff, we've not had an opportunity to see anything, respond to it, study it, develop the usual analysis and response that staff would have. So I'm not making an objection to this point, but I'm reserving the objection and flagging it for the record.
Are you saying as far as Mr. Lansford's testimony?
Yes.
It was filed.
Well, Mr. Graham and I don't agree on much, but I will say that well before their testimony was done, I think we specifically said we were withdrawing it, we weren't going to offer it, and so I think if I was in his shoes, I would probably be making the same point.
All right.
Judge, this is Nathan Williams for Public Counsel. I don't see the relevance of it other than perhaps some testimony about how production tax credits might work with a tax equity partner, but in terms of the specifics for a particular transaction that is not occurring, I think it's wholly irrelevant. So.
All right. Well, we'll table it, we'll set it aside and revisit it if we need to.
Thank you for indulging me, Judge, on that. Our next witness, Judge, is Mike Gronowski.
All right. All right, Mr. Gronowski, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Gronowski, would you please state your name for the record and spell it for the court reporter?
My name is Michael Gronowski. That's spelled M-I-C-H-A-E-L. Gronowski, G-R-A-N-O-W-S-K-I.
Mr. Gronowski, did you cause to be prepared for filing in this docket, sir, rebuttal testimony?
Yes,
Marked as Exhibit 5?
yes, I did.
Do you have any corrections to that testimony?
I do have one.
Okay. Can
If
you
you would
please tell us
please-
what it is?
If you would please turn to page 9, line 11. Preceding the word "in," there should be 2 sets of quotation marks.
Any other corrections?
No, that's it.
If I were to pose the questions in that testimony, would your answers with that correction be the same as they are in your pre-filed testimony?
Yes, they would.
Is that testimony true and correct to the best of your knowledge, information, and belief?
Yes, it is.
With that, Your Honor, I move for the admission of Exhibit 5 and tender Mr. Gronowski for cross-examination.
All right. Is there any objection to the admission of Exhibit 5? All right, hearing none, Exhibit 5 is admitted. And Ms. Plagia, do you have any questions for the witness?
No questions. Thank you, Your Honor.
Mr. Opitz?
No, thank you, Judge.
All right. Mr. Thompson?
No questions, Your Honor.
And Ms. Greenwald?
No questions, thank you.
All right. Mr. Williams?
Not at this time, thank you.
Mr. Graham?
Mr. Gronowski, were you here earlier for the testimony of Mr. Michaels?
Michaels? Yes, I was.
Do you concur that the purpose of the project is not to, doesn't matter whether the project's revenues meet its operational expenses?
Could you repeat that, please?
Do you agree that it, with respect to how the Boomtown project fits into Ameren's plan overall, its purpose, it doesn't matter whether its revenues meet its operational expenses.
I'm not familiar with the revenues that are going to accrue specifically that have been analyzed by Ameren. But at the same time, I'm also not familiar with a revenue test for a facility like this in a regulated environment. That's the first time I've heard of such a thing.
That's all I have.
All right, thank you. Chairman, do you have questions?
Thank you.
Any of the other commissioners have questions?
No questions, Judge Holzman.
All right. I don't have any questions myself, so thank you for your testimony.
Thank you, Your Honor.
And I have no redirect, Your Honor.
All right. Mr. Lowry, call your next witness.
Actually, it's Ms. Grubbs.
Oh,
I'll be calling
I'm
our
sorry.
next witness, which is Rob Dixon, to the stand, please.
All right. I'm sorry, just if you'll give me a second. All right, Mr. Dixon, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Ms. Grubbs.
Thank you. Would you please state your name for the record, spelling your last?
Sure. Rob Dixon, last name Dixon, D-I-X-O-N.
And by whom are you employed and what is your title?
I'm the Senior Director of Economic, Community, and Business Development for Ameren, Missouri.
And you are the same Robert Dixon who filed sir rebuttal testimony in this case, which has been marked as Exhibits 6C and B for the confidential, or I'm sorry, P for the public version.
I am.
Do you have any corrections or revisions to make to your sir rebuttal testimony?
I do. I have two minor corrections on page 22. Line 11 would ask to substitute the word that with the word than. And then on line 14 would ask to substitute the word subscription with the word solution. And that's all the corrections that I have.
So with those corrections, Mr. Dixon, if I asked you the questions in your testimony today, would your answers be the same?
They would, yes.
Mr. Dixon is tendered for cross-examination, and I would move to move his exhibits into the record.
All right, those are Exhibits 6C and 6P. Are there any objections to that? All right, then 6C and 6P are admitted into evidence. And Ms. Plesia, do you have any questions for the witness? Could I get you to turn your microphone on?
I'm sorry.
Right.
Good afternoon, Mr. Rubenauer.
Dixon.
I'm sorry, Mr. Dixon.
Yes.
I apologize.
No problem. Good afternoon.
I'm sorry. I'll reserve my questions for him. I'm sorry. I apologize.
All right, Mr. Opitz?
No questions, Your Honor.
Mr. Thompson?
No questions, Your Honor.
All right. Ms. Greenwald?
No questions, Your Honor.
All right, Mr. Williams, any on behalf of Public Counsel?
Not at this time, thank you.
And Mr. Graham?
One, I think. Are competitive electric rates an important consideration for attracting new customers?
Yes, they are, and we're proud of the track record we have on that.
So all I've got.
Okay. Chairman?
Yeah, just, right, he's under oath, right?
He is under oath.
So now that you're under oath,
Yes, sir.
how do you like the new position?
I'm enjoying it. Today, we'll see how today goes, but other than that, I'm really enjoying it.
All right, great. Now officially in the transcript.
Yes, sir.
All right. Any questions from the other commissioners? All right, hearing none, I've got a couple of questions. You've been here this morning and heard testimony, so it's no secret that the actual solar panels will be located in Illinois, correct?
Yes, sir.
Why would a company want to locate in Missouri when the source of the renewable energy is located in Illinois?
I think as some of our witnesses have talked about today, Your Honor, that generation off of the Boomtown project would be a part of the Ameren, Missouri generation mix, and that's what we would bring to customers who are looking to expand here or considering a relocation to our state, and talk about the overall generation mix that they'd be able to access, and it'd be through that process that they could do that.
Would there be any benefit to a company wanting to relocate here to have both the generation, both the panels and their electric provider both in Missouri?
I don't think there'd be a specific benefit to that scenario. The benefit that we would look for is to be able to talk about the fact that there is a renewable energy mix wherever it's coming from in that regard.
So nothing as far as you can't envision like a public relations benefit of being able to say that these panels are in Missouri?
It's part of the Ameren, Missouri generation mix, so no, sir, I don't think
Okay.
having it next door like that would matter in that regard.
Okay. I'll state this generally. Do any of the parties have any recross based on my questions? All right. Hearing none, Mr. Lowry, any redirect? I'm sorry, Ms. Grubbs.
Just briefly.
Grubbs or
if I-
Grubbs?
Grubbs.
Grubbs, okay.
Thank you. Just briefly, you mentioned in response to staff counsel's question that there was a history of low rates. Can you just clarify that further?
Sure. When a business or a potential customer is looking at where to relocate, they're looking at a variety of factors, and one of them that we know that they look at is energy availability, reliability, cost. And Ameren, Missouri has historically had a track record of having lower costs than other utilities in the state, and certainly in the Midwest and the U.S. overall. That's something that enhances our ability to attract new customers and create jobs in Missouri.
Thank you. Those were all of my questions.
All right. All right, Mr. Dixon, you're excused.
Thank you.
Thank you. All right, call your next witness.
Thank you. The company calls its next witness, Lindsay Forsberg, to the stand, please.
All right, Ms. Forsberg, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Ms. Forsberg, could you please state your name for the record, spelling your last?
Lindsay Forsberg, Lindsey. Forsberg is Forsberg.
By whom are you employed and in what capacity?
I'm employed by Ameren, Missouri as a strategy consultant on the renewable development team.
And you are the same Lindsay Forsberg who filed direct testimony in this case, which has been marked as Exhibit 7. There's actually a highly confidential version, a confidential version, and a public version, correct?
I am.
And do you have any corrections or revisions to your direct testimony?
I do not.
You are the same Lindsay Forsberg who filed supplemental direct testimony in this case, which has been marked as Exhibit 8. There's a highly confidential, and public version of that as well, right?
Correct, I am.
And do you have any corrections or revisions to that?
I do not.
And then finally, you are the same Lindsay Forsberg who filed surrebuttal testimony in this case, which has been marked as Exhibit 9. There are highly confidential, and public versions of that.
Yes.
And any corrections to your surrebuttal?
No corrections.
So if I asked you the questions within your testimonies today, would your answers be the same?
They would.
I tender Ms. Forsberg for cross-examination and move her testimony into the record.
All right. Are there any objections to the admission of Exhibit 7, the highly confidential, and public versions of that exhibit? Exhibit 8, again, highly confidential, and public versions. And Exhibit 9, public and highly confidential versions of Ms. Forsberg's testimony. Any objections? All right, then Exhibit 7HC, 7C, 7P, 8HC, 8C, 8P, 9HC, and 9P are all admitted into evidence. And Ms. Pleshia, do you have any questions for the witness?
No questions, thank you, Your Honor.
Mr. Optics?
No questions, Your Honor.
All right. Mr. Thompson?
No questions, Your Honor.
And Ms. Greenwald?
No question.
Mr. Williams?
Not at this time, thank you.
Mr. Graham?
Thank you. The work papers provided in support of the net present value of revenue requirement associated with the Boomtown project indicate that the resulting values assume perfect rate making. Are you familiar with that expression, perfect rate making?
Yes, I am.
What does that mean?
I think it means that essentially all costs and revenues from the facility would immediately be rolled into base rates with no regulatory lag.
Okay. Does Ameren, Missouri expect for this assumption to reflect the reality of general rate case timing throughout the operational life of this asset?
No, I would expect there to be some impacts of regulatory lag. Part of why we modeled the project that way was we put together a new model specifically to look at a tax equity partnership, and that model had so much complexity in it already, it wasn't possible to layer that on as well.
Your work papers indicate an assumption of perfect rate making, correct?
That's correct.
But you don't expect those assumptions to be borne out for the reasons that you've just stated, correct?
No, but I wouldn't expect that change to materially change the results presented. It would be certainly a small impact, though.
If the perfect rate making does not occur, well, do you know what the acronym, I hope this isn't the name of a river that I messed up before, NPVRR. Are you familiar with that acronym?
I am.
Would you tell me what it means? Doesn't refer to a river, right?
It does not.
I'm so pleased.
The net present value of revenue requirement.
And if perfect rate making does not occur, the NPVRR of the project realized by the ratepayers will increase, correct?
I don't know if that's true.
Okay, that's your answer.
That is my answer.
Although I assume that you hedged that answer, no disrespect because I chose that word, but we use it in finances, because of the assumptions that would have to be made, correct?
The assumptions and the fact that I haven't done that specific analysis, so I can't comment on it.
Okay, well, I will leave it there then. Now, the results of Table 1 on page 5 of your surrebuttal, are you familiar with that?
Yes.
They assume that Ameren utilizes invest tax credits and a tax equity partnership, correct?
That's correct.
Did Ameren review the NPVRR of the project, assuming the increased boomtown costs if production tax credits are utilized?
We did compare the potential outcomes for customers for both the PTC and the ITC. And under the increased project cost, it appeared the ITC was more favorable for customers, resulted in a lower net present value of revenue requirement. So that's why those results are presented in Table 1.
So assuming production tax credits are utilized, do any of the scenarios considered in Table 1 of your SIR rebuttal result in an expected NPVRR reduction?
I may need you to clarify the question. Table 1 assumes the investment tax credit, so it seemed like you were asking about the production tax credit.
I did, and I'm
Okay.
sorry. Now, wait just a minute. I'm asking about the scenarios. So if you don't know, that's fine, but assuming the production tax credits are utilized, do any of the scenarios considered in Table 1 of your SIR rebuttal result in an expected NPVRR reduction?
I don't know.
Okay. Have you been here for the testimony of earlier witnesses today?
Several of them, yes.
Mr. Michaels?
Yes.
Okay. Do you concur that the overall plan that's involved here, that the Boontown project fits into for the purposes of that plan, whether or not the revenue of the Boontown meets its expected operational costs over its life? That's not something that Ameren is concerned with one way or the other. Do you agree with that?
I do agree with that.
Thank you.
Chairman Root, do you have any questions? No. Okay. Answer is no. Do any other commissioners have questions for the witness?
No questions, Judge. Thank you. Holzman.
All right. All right, Ms. Forsberg, I do have some questions myself. Well, let me ask you this first. Has there been a decision on whether to utilize investment tax credits or production tax credits?
There has not been a decision.
Okay. Could you explain what the investment tax credit is and how it works?
Sure. So the investment tax credit is it's basically an upfront refund on some of the project costs. So the ITC is dependent on the cost of the project, and you get a certain percentage of that back as a tax credit. So the standard is 30%. That's the ITC standard. One of the really great things in this case is that this project is in an energy community, as we've discussed, so that means it qualifies for an additional 10%. So the ITC at 40% would mean you get basically a 40% check back from the IRS for the cost of the project.
And how does tax equity financing come into play with that investment tax credit?
So it's a way to potentially utilize the value of the investment tax credit. Some people in this room are probably aware that there are specific rules for utilities. If they do elect the investment tax credit, they have to do what's called normalization, and they give that value back over the life of the asset, which then when we're looking at present value of revenue requirement, it sort of reduces the value, right, if we're focused on that present value. So tax equity financing is a way to capture all of that value in year one and to make sure it really reduces the present value. So it's just a different way to capture the value that I think can be more valuable.
Can investment tax credits be sold like I believe production tax credits can?
They can, yes. This is new in the Inflation Reduction Act. So both the production tax credits and the investment tax credits can now be sold to other entities for cash.
But that wasn't the case before.
That was not the case.
Okay. What are the differences between the two tax credits, and why would you choose one over the other?
So the production tax credit is a credit back per kilowatt hour generated. So it depends on how the resource performs, what amount you ultimately get back. The rates for the production tax credit are very high, so that can be a really good option. It's been a great option for wind for a long time, and it's now an option for solar as well. So, you know, depending on what you think the production of the resource is going to be, you might select production tax credit. The investment tax credit, you know, some of the interesting trade-offs is that in the investment tax credit is tied to project cost. So one of the considerations here is that the project cost has gone up, which increases the value of the ITC. So that's one of the things we're weighing. So I really think those are probably the main criteria. You'd look at the project cost versus the expected production and see which one you think will be more valuable.
When considering those two tax credit programs, does the timing of implementation of the project come into play?
A little bit, but with the Inflation Reduction Act, those tax credits have both been extended pretty significantly out into the 2030s. So it's not as much of a consideration as it was previously.
Are amortization, allowed return, that type of thing, is that a consideration?
As far as I know, those are essentially comparable between
Okay.
the two options. Yep.
And I can't recall if Mr. Graham referred to this particular table. I don't think so. But in your rebuttal testimony, there's a schedule S1 and S2.
Yes.
Are those based on the presumption that you're using investment tax credits?
They are, yes.
Okay. Does it therefore assume that a portion of the project cost will be financed through tax equity financing?
That's how a tax equity partnership would work, right? And then the partner sort of recoups that investment through project revenues. So it sort of ends up, you know, on balance the same. They just pay certain costs up front.
On page 2 of your rebuttal testimony, and I think it spills over into page 3, you indicate that Ameren's analysis has indicated that the investment tax credit is more favorable than the production tax credit. With the introduction of the Inflation Reduction Act and changes to the project cost. Is that correct?
That's correct.
Okay. Similarly, on page 3, you indicated that Ameren will make a decision on tax equity financing at a later date. So Ameren has not decided, and I think you answered this already, but they have not decided which tax credit program they're going to use.
That's right. Maybe I can clarify too. There's one particular nuance of the rules that we're waiting on clarification from the IRS, and that's related to the transferability of tax credits and whether or not the cash you get from that transfer would still be subject to normalization. So we're hoping, you know, if we wait a bit, we may get guidance from the IRS. If they clarify that in a way that means we can transfer the tax credits and do not need to normalize the cash, then I think that would make the ITC with a transferred tax credit pretty equivalent in value to the tax equity partnership for customers. So we're kind of waiting to see if we get that guidance, and then we can determine if we need a tax equity partner.
Okay. In the two Sir rebuttal schedules, 2 schedules attached to your sir rebuttal testimony. That's all based on the ITC.
That's right.
Is there some reason why you wouldn't provide a similar analysis for the production tax credit?
No, I certainly could. At some point in the case, we provided a table to parties that showed, not a table, a chart that showed the crossover points in customer value. I think my counsel provided it by email, but
Okay.
we could.
Was that in response to a data request?
It was just to give parties a heads up that we were reevaluating the tax strategy.
In that schedule S1, the title of that schedule says Boomtown Solar Project Modeling Assumptions. So are these the same assumptions that are used to, that led to those results in Schedule S2?
Yes.
Okay. Can you explain what each assumption means
In
S1?
S1?
Yeah.
Do you want me to just walk through the whole table?
Sure.
Okay, great. So the project parameters, the first size there, that's the nameplate capacity, AC.
Okay.
The total delivered cost at COD is the expected total cost of the project.
And I would just interject that this is all marked highly confidential, so
right.
We'll just caution, the values, yes.
Yeah, I can just explain and not state the values.
Thank you.
Okay. Then below that, you'll see broken out the 2 amounts of that total cost at COD. That's a value that the model solves for. If we were to pursue a tax equity partnership, some of the upfront costs would be paid by the partner, some would be paid by Ameren, Missouri. So sponsor AMO equity would be the portion that Ameren, Missouri invests. Then we have the expected mechanical completion and COD date. So that would be when the project is commercially operational. The expected project life. And then we assume there would be some costs associated with finance, with putting together a tax equity deal. So that's what that TEI deal costs refers to. Then we have a variety of parameters for the revenue requirement, debt and equity percentage, cost of debt, cost of equity, discount year, WACC, discount rate. Those are all things that are kind of consistent with our internal corporate modeling that were provided.
And when you say WACC, WACC,
Yes.
Weighted average cost of capital?
Weighted average cost of capital, right. Then below that, we have the different expected production levels for the project that we tested. So these are the capacity factors. P50 is sort of the average or expected capacity factor. So the 25.8%, that's the base capacity factor used in our analysis. And then we always want to test lower values just to see what would happen if the resource performs at a lower rate. For solar projects, we also assume an annual degradation because solar degrades over time. So that's the 0.5% that you see. I don't think that's highly confidential. Now that I've said it. Then below that, the revenue and price assumptions. So for energy and capacity revenues, we have used forecasts consistent with those developed by Matt Michael's team through the integrated resource planning process. And because the project is located in Illinois, we also applied a basis adjustment for the specific location of the project. Then if you go to the other column, we've got ongoing expenses modeled in the project. So, obviously we assume that there will be expenses for the project, no fuel costs because it's a renewable resource, but we will have property taxes that will be paid over the life to the county, and ongoing operations and maintenance expenses, real estate expenses in this case would be land leases for the site that the project is on. And then some of the interconnection costs are paid over 20 years. So those costs are reflected as ongoing expense. Below that, we have some assumptions associated with the contract for differences. So this would be a specific nuance that applies only if we do a tax equity partnership. It's part of how the partner gets paid back and recoups their investment, is you set sort of a starting price for that contract for differences, and part of the revenues that they get to recoup their investment are dependent on that. Then below that, we get to the tax items. So the ITC rate, this is what I was just discussing with the energy community boost. That value goes from 30% to 40%, so you'll see that reflected. Then there's some additional tax assumptions below that about what percentage of the project costs will qualify for the ITC. So that's the 5-year makers, 15-year makers, and then the ITC percent on each. There's certain costs of the project that are excluded from qualifying for the investment tax credit. We did assume 12-year straight line alternative depreciation, so that's reflected. And then the federal and state tax rate, those are fairly standard. And then below that, we have a variety of specific assumptions for the tax equity partnership. Those would depend on the specific transaction we enter into with the tax equity partner, if we were to do that. So things like flip yield, target flip yield, what share of the revenues the tax equity partner is getting. Those things would be dependent on the specific deal. I will say for these assumptions, we worked with a group called CCA. They're pretty much a recognized expert on tax equity deal structures to, for one, develop the model and to come up with those assumptions.
And so are all those assumptions used to come up with your figures in that Schedule S2?
That's right. Yep.
Can you explain how you arrived at, I hate to make you go line by line, but I'm trying to understand the net partnership cash flows. How did you calculate that?
Where is that? Are you looking at table S2?
Schedule
or?
S2, yes.
Oh, okay. Oh, the net partnership cash flows. Right, so that's essentially, it's calculated in the model. It's based on the expected energy revenues from the project and the expected capacity revenues. And then from that, there's a portion that gets sort of, I think the word that's often used is swept by the tax equity partner so that they recoup their investment. So like I said, they pay some of that capital up front and then they make sure they recoup that through those costs.
And I apologize if this has already been mentioned, but PWA stands for?
That stands for probability weighted average. So that's our sort of middle curve assumption from the IRP.
Okay. And then the next line item, net CFD, what does CFD stand for?
So CFD is the contract for differences. That's another just specific nuance of the tax equity partnership that would exist and has an impact on the ultimate project revenues that Ameren, Missouri would see. That's why we've reflected it.
So is that something that would not come into play if it were production tax credits?
Right, or if we used the investment tax credit and transferred the value.
The line credit to subscribers, what kilowatt per hour consumption is used to calculate this parameter under that P50 output scenario?
Sure, so the columns on the left side of the table assume that P50 value, the 25.8%, and that's kind of utilized in combination with the credit rates for the Renewable Solutions Program that are set out in the tariff to calculate what that would be.
Okay, so there's no, as far as kilowatt hour consumption?
It's based on kilowatt hour generation from the resource.
Okay.
Yep.
Okay. And then the figures on the line revenues from subscribers, can you help explain that? Help me understand that?
Sure, so that would be the revenue that subscribers pay into the program through the program charge rate. So as the Renewable Solutions Program is laid out, there's a charge and there's a credit. So that's what those two lines are representing. And then below that, you see the net impact of those two line items.
Okay, and how are those allowed return figures? How do you come up with those?
So essentially, these results are from the tax equity model that we developed, and we essentially just built a tiny revenue requirement model within that. So there's a whole host of assumptions that go into that.
And how do you come up with the operating expenses numbers?
So those are project specific. For this case, we have O&M, we have interconnection costs. Those are laid out specifically by MISO in the generator interconnection agreement. We have property taxes, which, like I said, are county specific. So our tax team essentially estimated those based on specific laws of White County, Illinois. And then the land leases are also kind of known in advance. Those are set by the developer, whatever they agreed to with the landowners.
And I assume that the TEI deal cost would not be a factor if you were going with production tax credits.
Correct.
Okay. Are there work papers that would allow the commission to see how you arrived at those numbers?
Yes, I've provided those.
You have provided those?
Yes.
Okay, to?
I'm not sure how that works logistically, but they've been provided.
Once the testimony is submitted, then the work papers are circulated to all of the parties.
I see, okay. All right, now I want to turn to your direct testimony.
Okay.
This first schedule, D1, is, I believe, the subscriber contracts.
Yes.
The first line of each agreement states, the undersigned customer subscribes up to a specified number of kilowatt of renewable power over a specified term, and then it says RE service. Please expand on what is included in RE service. In other words, what are they getting? What's each customer getting for what they are paying for?
I expect it's defined below, but we will see. It may not be a defined term. One moment. If it has a specific definition in the tariff, I may get it wrong, but I can just speak generally to what that refers to, if that would be helpful. Essentially what they're getting through the program is title to the renewable energy credits generated by whatever portion of capacity that they subscribe to.
Okay.
So I hope somewhere in here it's defined somewhat like that.
And just so that the record's clear, it is a part of the proposed tariff, which on EFIS is document number 11.
Okay.
Oh, I think that's my confusion. I have the contract, not the tariff in front of me. Thank you.
There is, correct me if I'm wrong, there is a First Amendment to the RSP agreement?
I believe that's correct.
Do you know what was amended that resulted in that First Amendment?
Is that referring to the updated pricing? Yes, we updated the project, or the charge rates. Yes, we updated the charge rates for the program.
What project cost was the renewable resource rate in that First Amendment to the RSP agreement based on?
So I believe, in my memory,
Without getting into confidential information.
I believe it was based on a project cost similar to the base case presented in my direct testimony, but I am not 100% sure.
believe it's in roughly the second or third page of these contracts. There's the term renewable resource charge, and it's defined as a charge applied to the monthly energy statement of subscribers. The renewable resource charge will be calculated as the subscriber's RE service level multiplied by the renewable resource rate, provided that if company, Ameren, is unable to meet subscriber's RE service level as a result of the occurrence of an act or event described in item 10 of the other program provisions in terms of this rider RSP, the RE service level in the equation above shall be reduced to the level company can supply during the period company's performance is reduced or delayed. Which P case net capacity factor is needed to meet the subscriber's RE service needs?
So the portion of the program costs that you're referring to, the charge rate, is based on capacity, not on generation. So that's a per kilowatt charge.
Okay. So no relation to, well, would reduced revenue due to an act or event impact project revenues?
Reduced production?
Reduced revenue?
Reduced, can you clarify, reduced revenue for who?
Well, lower revenue due to an act of God, let's say.
It would hurt the economics of the project, certainly. But I would say the way the program is designed, customers pay a fixed charge per kilowatt and they get a credit back per kilowatt hour. So in the case that the resource underperforms, subscribers actually pay more into the program. So it's kind of a nice risk mitigation for other customers for some of those lower P cases.
So if there is not as much renewable energy generated, are you saying that subscribers will cover
more of the cost?
That deficit?
Yeah.
But not all of it?
No, not all of it, but they pay more into the program, and they offset a pretty significant portion of that risk.
And you were here earlier when I asked Mr. Aurora about insurance covering force majeure. Are you familiar with that?
I'm not.
Okay. I think you touched on this earlier, but I'm going to take you back to your surrebuttal schedule S1.
Sure.
So in that first column, there are these different net capacity factors.
That's right.
Do they represent the average annual capacity factor?
So they represent modeling of the project that is designed to create kind of a standard deviation curve over the full life of the project. So if you can imagine sort of a, the normal curve you've seen a million times, P50 would be right in the middle. Okay. So that means that in 50% of years, you'd expect the production to be above that, and in 50% of years, you'd expect it to be below. And then as you go to lower P values, it just increases the certainty that production will be above that level. So P99 should be the value where in only 1 year out of 100, you would see production below that level.
And this annual degradation factor of 0.5%, how is that incorporated into that analysis?
So it shows up in the project model. It essentially just takes a small haircut on the expected megawatt hours generated each year. I don't know a ton of specifics about it, but it's just a fact of life for solar projects that over time they produce slightly less each year. In
that same schedule, you show a discount rate of well, I don't know if that's confidential information.
Probably is.
Um,
I can see it though.
Okay. What's the basis for that discount rate?
So as I understand it, I'm calculating WACC is a pretty standard process. Internally at Ameren, we also use a discount rate that is just I think it's post-tax WACC. So it's just an adjusted level of the WACC based on taxes.
Your modeling scenarios, other than price, do you consider the generation level or the resource output?
Yes, so there's I would say 3 variables we focused on most in creating the 12 scenarios you see in my direct testimony. Mostly we focused on those variables because they have a pretty big impact on the project economics. So one is project cost. We varied that. The second is expected generation output or production. So that's the P50, the P99 levels we've been talking about. And then the third is the expected or forecasted energy prices that we looked at to assess how much revenue the project would generate. So for those, we looked at 3 levels that correspond with the integrated resource plan: the high prices, low prices, and probability weighted average.
On that Schedule S2, can you explain how the amortization amount was calculated?
I would have to get out the work paper and walk you through it.
Okay. And I think you first touched on it in response to Mr. Graham's question, but the NPVRR that's presented in the schedule, what time is it for? Is it for the 15-year subscriber period?
It's for the full 30-year life of the project.
Okay.
Yep.
Okay, when I compare the schedule, I guess it would be D1. I'm sorry if I'm if I'm a little sloppy on these, but D1 versus S1, your direct testimony versus your sir rebuttal testimony, they're similar tables, correct?
I think you're referring to D2 versus S1. Is that what you're referring to?
That sounds right.
Okay. Yes, they should be identical with the exception of the project cost, which we've updated, and the ITC percentage, which, as we indicated, the project's now eligible for 40%.
But if I recall correctly, there's a significant difference in the amortization and allowed return figures. Why is that?
The project cost has increased, so that could be why.
Okay. When it comes to repairs or upgrades required for the project during the first 15 years, who will cover those costs? Will it be the shareholders? Will it be the subscribers? Will it be some combination?
So to price the program, we looked at all expected costs over the first 15 years of the program. So that included estimates for operations and maintenance. So certainly those estimates were included in the charge rate that we set for the program. If things arose beyond that we didn't expect, they wouldn't be reflected.
You've spoken about increased project cost. Did an increase in energy prices factor into your analysis?
We considered reflecting that because energy prices have also seen pretty significant inflation, but I'll say the reason that I modeled several energy price scenarios to start with was to capture some of that uncertainty, and that's what we set out to do in the IRP as well. So if you look at those different results, perhaps you could give a little more weight to the high price scenario under current conditions, but the future's uncertain, so we felt it was best to just stick with the range.
The investment tax credit, does it require a tax equity partner, or does it just make sense to use a tax equity partner?
It doesn't require a tax equity partner, but like I said, if Ameren were to just elect the ITC without a tax equity partner, we would be subject to normalization, which means we can't give all the value back to customers in year one. We have to spread it out over 30 years. And then when we look at, present value, the value of that credit is reduced dramatically. So really the only reason to pursue a tax equity partnership would be to capture the value more fully for customers.
And you mentioned earlier about where this particular project would be located is in an energy community, and that provides another 10% added on to the 30% tax credit that is already available.
That's right.
Was that included in your assumptions and the results that are presented in the SIR rebuttal schedules?
They are, yeah, that was included.
Okay. I think that's all the questions I have. All right. Ms. Pleshia, do you have any?
No questions, thank you, Judge.
All right. Mr. Optitz?
Oh, thank you, Your Honor.
Mr. Thompson?
No questions, Your Honor.
Ms. Greenwald? Mr. Williams?
Yes, thank you. Ms. Forsberg, do you recall when you talked about waiting for information from the IRS about normalization of proceeds from sales of credits?
I do.
Has Ameren, Missouri made some request of the Internal Revenue Service regarding normalization of those proceeds?
I don't think Ameren, Missouri specifically has, but I believe EEI, which I'm going to forget what that stands for, Edison Electric Institute, which represents investor-owned utilities in the industry. I believe they've made that request.
So Ameren, Missouri has not requested a letter ruling?
We're part of EEI, so it's sort of on our behalf. That's my understanding.
Well, where I'm really trying to go to with it, and I don't know that it matters that much, but are you trying to get a binding representation from the Internal Revenue Service for how you go forward, or are you just looking for some kind of a general advisory position by the IRS?
I'm not sure. I would have to ask our tax team. I just know we need some sort of guidance, some sort of rules or regulations to make it clear if we can take that cash and directly give it back to customers, or if we have to normalize.
Are you familiar with letter rulings?
No, I am not closely.
And then you talked about a degradation rate of, since it's public now at least, 0.5% per year, and the service life that you're using is a 30-year life. If I did the math right, that would be a 15% degradation, so a 150 megawatt facility should still be capable of generating 127.5 megawatts. Is that correct?
I think it's more appropriate to think of it in terms of megawatt hours and the impact it would have on production. That's a little simpler, but that's probably reasonable to think of it that way as well.
Well, if you have the same hours available,
yeah,
and you look at the capacity that it generates, is there a difference between looking at it megawatt hours and megawatts?
Probably comes out the same.
No further questions.
All right, Mr. Graham, do you have questions?
Yes, thank you. We are on the CFD schedule LJF-S1. Are you with me?
I can't hear you very well.
Mr. Graham, go ahead.
We're on the CFD schedule LJF-S1 schedule, okay?
Great.
Great. And I will not try to read out, or I will not read out confidential numbers, but starting with the column down under that title, contracted cash flow, CFD, that's underlined in bold. And read down to starting price, dollars per megawatt hour. Are you with me?
Yes.
You see that number there that we're not going to read out.
Yes.
Is that value higher than the expected average revenue from Boomtown in year one? Is that correct?
I believe it is, yes.
Okay. Next question, if the locational marginal price, the LMP for Boomtown, were less than the value titled starting dollars per megawatt hour, which we have just been referring to, who would pay that difference?
I have to say, if we want to get into the details of the CFD, I'm probably not the expert at the company on that.
Now, these tables that we've been looking at have been about the Renewable Solutions Program.
Yes.
All these operational expenses, all of these other expenses, every expense that we've been talking about has been about that program.
No, the expenses we've been talking about are the ongoing expenses for the resource itself, for the Boomtown
entire project.
Correct.
Right. And so you worked up 5 tables that concern expenses, not only the expenses of building the facility, but the expenses of operating the facility for its entire operational life, correct?
I'm not sure which tables you're referring to.
Well, the tables you've been referring to in your testimony here.
Those include the ongoing expenses for the project, yes.
Right out to the end of its operational life.
Yes, exactly.
Correct. But it was not important to Ameren that there be a comparison to establish whether or not those operational expenses over the operational life of the project would be covered by the revenues.
Which revenues?
That come in, the revenues that come in from ratepayers.
I may need additional clarification. Are you referring to the project revenues?
I'm talking about the project revenues.
Sure. I mean, I will say in the results I presented.
Let me just explain it this way.
Okay.
The ratepayers are going to have to cover a deficit. Is that right?
That's right. That's what the present value of revenue requirement results are designed to capture.
I'm sorry I didn't ask my question right. I just asked it the way that I intended to ask it, and I got the answer. Thank you very much.
Okay.
I'm done. Thank you, Your Honor.
All right, Ms. Grubbs, redirect?
Yes, thank you. So, Ms. Forsberg, when staff was initially cross-examining you, there was a question about the regulatory lag benefits. Do you recall that?
I do.
And so, is it true that the regulatory lag benefits are as proposed under the tracker to be tracked?
I believe so, but I may have to defer to Mr. Wills, my colleague, on that.
And any revenues that are generated by the project's production would flow through the FAC, at least in the interim. Is that correct?
Correct.
So on cross-examination from staff, you also described, or you asked about the overall plan and whether Ameren, Missouri was looking at revenue meeting all costs. Do you remember that?
Can you say that again? Sorry.
Sure. I believe it was staff counsel's cross-examination. He asked whether Ameren, Missouri had been looking at revenue meeting all costs.
Oh, yes.
Yes. And so how was the the program designed to address revenues and cost?
So we did layer the program revenues and costs on top of the revenue requirement, and that's some of what I went through with the judge. And so those kind of feed into the overall revenue requirement, and really what we're seeing is across essentially every feasible scenario, subscriber contributions lower the revenue requirement of the project, and it's a benefit to all customers in that way.
And then I believe it was the judge's questions. Just want to clarify, there are two tax strategies that are options under the ITC. So with tax equity partnership and without, as you described it, then just transferability. Is that correct? Right. And so what was reflected in your surrebuttal attachments or schedules, LJF, S1 and S2, which tax strategy is reflected in those?
In the surrebuttal testimony, we assumed the investment tax credit.
And with tax equity partnership?
With tax equity, solely because, as discussed, we don't have full clearance from the IRS on the other option.
And I believe you were discussing Schedule LJF S1, and you used a term makers. Can you just define that so that the record's clear?
Ooh, that's a good test, if I can remember what it stands for. Accelerate, oh, I might need help, sorry.
Okay.
Do you have it, Jermaine?
I don't.
Okay, apologies.
So then the judge was asking you some questions about the First Amendment to the agreements, the repricing that occurred?
That's right.
Are the updated charge rates that you described reflected in the tariff that's been proposed and submitted in this case?
Yes.
Yeah, I think that's all I've got. Thank you.
All right. All right, thank you, Ms. Forsberg. You may step down. Let's go ahead and take a break, and reconvene, I'll say at 2:55. All right, let's go back on the record. It's about 3:02. Ms. Grubbs, Mr. Lowry, call your next witness.
Thank you, Your Honor. Call to the stand Scott Wibbenmeyer, please.
All right, Mr. Wibbenmeyer. Good afternoon. Would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Ms. Grubbs.
Thank you. Please state your name for the record, spelling your last.
Scott Wibbenmeyer, Wibbenmeyer.
By whom are you employed and in what capacity?
Ameren, Missouri. I'm Director of Renewable Development.
And you are the same Scott Wibbenmeyer who filed direct testimony in this case, which has been marked as Exhibit 10. There's an HC highly confidential and public version of that, correct?
That is correct.
Okay. Do you have any revisions or corrections to make to your direct testimony?
I do not.
And so if I ask the questions contained in your testimony today, would your answers be the same?
They will.
Mr. Wibbenmeyer is tendered for cross-examination, and I move for 10HC and 10P to be moved into the record.
All right. Are there any objections to those documents coming into evidence? All right, hearing none, 10P and 10HC are admitted into evidence. And Ms. Pleshia, do you have any questions for the witness?
Yes, I do have questions for this witness. Mr. Wibbenmeyer, good afternoon. I just have a couple of questions pertaining to land. If you know, could you explain or tell me the amount of land that's required for the Boomtown Solar Project?
Absolutely, and I'll give estimates
Sure.
because everything's final. But Boomtown's not a small project. At 150 megawatts, these solar projects take quite a bit of land to put in production. So when we look at Boomtown, it's about 1,200 acres will be utilized for the facility itself. And then there's almost double that we'd call undeveloped land. Maybe it's ditches or just not usable that the site may be keeping from others using it for farming or whatnot, or it's land that wasn't used in the past. So 1,200 for the site specific, though.
So would you say an acre is roughly the size of a football field?
That's probably a fair comparison.
This would be like 1,200 football fields, and maybe 2,400 if you consider all the land that's not usable. Is that fair to say?
Correct.
Okay, I don't have any further questions. Thank you.
All right. Mr. Opitz?
No questions, thank you.
All right. Mr. Thompson, do you have any questions?
No questions, Your Honor.
All right. Ms. Greenwald? All right. I don't know if that was captured. No questions. Mr. Williams?
Not at this time, thank you.
Mr. Graham?
Not at this time. Not at this time.
Mm-hmm. Chairman Roop? Any of the other commissioners have questions? All right. I've got just a couple questions, Mr. Wibbenmeyer. Let me find your testimony. On page 7 of your direct testimony, you speak to the estimated capital costs of the project. How was that dollar figure arrived at?
So that dollar figure really came from our RFP process, right? We had an open bid process to see what projects came out. Part of that evaluation or part of that bid process was a price. As we screened down through those projects, and we narrowed out, would say the more risky projects got down to the preferred projects. So that was that 51 projects down to 9. When we start looking at diligence, we start negotiating with the contractors or the developers really around their price, understanding where their price is coming from, what would they do the project for, or kind of refining their bid and understanding it. And that's where that price came from at that time.
And when you arrived at that price, when did you arrive at that price? What date?
So that price, I don't know if I recall a specific date, but it would have been early 2021, right before we signed the BTA.
Okay. And you've since revised?
Early 2022, late 21, sorry.
Okay.
You know, years picks up.
But you have since revised that estimate, correct?
That is correct. That's correct.
When do you expect to finalize the cost of the project?
One of the obligations under the BTA is the developer 30 days prior to firm date or prior to both parties agreeing that we'd move forward with this to give us a final cost estimate. So that 30 days is when we would expect to get the final numbers from the developer. With that said, we've gotten preliminary numbers based on competitive bids for some of the major equipment and the major contractors since that time. That's where the new numbers are derived from. So we would not expect a lot of deviation from that, but more refinement from the developer as we move forward.
How would, assuming those numbers change, how would that affect the Renewable Solutions Program? What the subscribers would be asked to pay?
Probably, and I'm not the right expert to discuss the Renewable Solutions Program. I think as it sits now, the tariff would go unchanged, but Steve Wills would probably be the right expert on that question.
Okay. And again, you may tell me the same thing and answer this question, that you're not the right witness to ask this question, but under that RSP, who will be responsible for the operating expenses of the project?
So the programs are the Boomtown projects being proposed because we have an energy need. So under that need, we would expect Ameren to run this plant like it does all of its facilities, and that O&M cost would be bared similar to other facilities within our rates.
If there are changes in the project cost beyond what was used to develop the renewable resource rate, who will be responsible for that?
Again, this project we were proposed that this project is needed with or without that program, and therefore it would be captured in rates. The program really offsets costs and brings benefit to the customers ultimately.
Okay. All right, Ms. Plashia, do you have any recross?
No, thank you, Your Honor.
Mr. Ops, I don't know why I'm having problems with your name today, but go ahead and state your name for me. Mr. Opitz. Okay. Mr. Thompson.
No questions.
Mr. Greenwald. No questions, Your Honor. All right, Mr. Williams.
No, thank you.
All right. And Mr. Graham.
No, thank you.
All right. All right, Ms. Grubbs, do you have redirect?
I do not, thank you.
Okay. Then, Mr. Whitmire, you're excused. Thank you.
Thank you.
All right, Ms. Grubbs, call your next witness.
And it's back to me, Judge. It'll be Mr. Steve Wills.
Okay. right, Mr. Wills, raise your right hand, please. Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Wills, would you please state your name for the record?
Stephen Wills, spelled W-I-L-L-S.
And Mr. Wills, what's your position?
I'm the Director of Regulatory Affairs for Ameren, Missouri.
Did you cause be prepared for filing in this docket direct testimony that's been marked for identification as Exhibit 11 and sir rebuttal testimony that's been marked for identification as 12-8C, 12C, and 12P, the three versions of sir rebuttal?
Yes, I did.
Do you have any corrections to any of those testimonies?
Just a couple, on the sir rebuttal only. On page 40 of the sir rebuttal testimony, I just wanted to point out that there is a formatting error on table 1, but in the center column labeled base, as you go down, there's certain numbers that kind of wrapped into the cell below. So for the subscriber charges on the base, it should read 14,886,000. That trailing zero is a part of the number that fits in there. Same thing on the renewable energy to subscriber kilowatt hours. It should be 339,012,000. So the wrapped zero should be a part of the number. And I've got two more of those. On subscriber credits, it should be 13,153,666. So the 6 that wraps in there. And on the market revenue to benefit of non-subscribers should be 11,865,420. So again, there's just the zero belongs with the line above it. Then on page 48, on line 15, the word provide should be provided. And on line 17, there should be a period at the end of the sentence, at the end of line 17. And that is all my corrections.
With those corrections, if I pose the questions in Exhibits 11 and 12, each of those three versions to you again here today, what would your answers be the same?
Yes.
And those answers are true and correct to the best of your belief?
Yes.
With that, Your Honor, I would offer into evidence Exhibits 11 and 12, all three versions, and tender the witness for cross-examination.
All right. Are there any, excuse me, any objections to those documents coming into evidence? All right. Hearing none, Exhibit 11 is admitted, and the three versions of Exhibit 12 are admitted. And Ms. Pleshia, do you have any questions on cross-examination for the witness?
No questions, thank you.
Mr. Opitz?
No, thank you, Your Honor.
Mr. Thompson?
No questions, Your Honor.
Ms. Greenwald?
No questions, thank you.
Mr. Williams?
Not at this time, thank you.
Mr. Graham?
Okay, Mr. Wills, can we discuss the contract for differences, assumptions, including in Ms. Forsberg's sir rebuttal testimony at LFJ-S1?
I don't have a copy of that testimony, and I will do my best to answer questions about it. Like Ms. Forsberg, I'm not, the company's expert on that, but if someone wants to present me with a copy of it, I'll answer what questions I'm able to.
Mr. Graham, can I ask you to...
Let me just jump down
adjust your
here and,
microphone.
I'm sorry.
Yes, I was going to ask you
Thank
to
you.
adjust your microphone.
Well, let's see if we can get some information without reference to specific numbers. Assume a tax equity partnership. If the locational marginal price for Boomtown were less than the value that's titled in that document without reference to the numbers, starting dollars per megawatt hour, ratepayers will pay that difference. Is that correct, or do you know?
I mean, not having it in front of me, I don't know what the starting dollars per megawatt hour refers to. So I guess the answer is I don't know.
No, that's fair. Since Ameren, Missouri supplemental direct filing in this case indicated that the company did not expect to pursue a tax equity partnership, staff and other parties did not have an opportunity to provide written testimony responsive to potential concerns of that approach. Is that correct?
That is correct.
And you heard any number of questions that came from the bench in that regard. Is that correct?
Are you you're referring to Ms. Forsberg?
Yes, I am, sir.
Yes.
Okay. Ameren indicated that the company would not move forward with this project if the staff's recommended hold harmless was ordered. Are you familiar with that? Is that the company's position?
I don't know that we've stated that in testimony, but I do believe that is our position, yes.
Would Ameren move forward with this project if the risk that the project's costs exceed revenues were shared among shareholders as well as ratepayers?
No, we would not. There's really no economic litmus test for a needed project in terms of it paying for itself. I mean, with anything that we need to provide service, so for example, the transformer hanging out outside of my house, the transformer hanging outside of your house, it doesn't provide revenues, but it's needed to provide service. The costs of that are reflected in the revenue requirement that are used to set rates. The Boomtown facility is needed to provide service. Now, the fact that it can provide market revenues is great, and it actually might pay for itself, but there's really no reason that the company would assume the risk that it will pay for itself when it's a needed asset that we have to invest in for the benefit of our customers.
So the need for this project, with respect to the first Tartan factor, are you familiar with the Tartan factors?
Yes.
The need is not so great that it would make economic sense for the company to share in any part of the risk.
I'd say it the other way, that the need is so great that it wouldn't make sense for us to share in the economic risk for it.
You would. All right. Thank you. That's all the questions I've got.
All right, Chairman Roop, do you have any questions?
I do. Good afternoon.
Good afternoon.
So maybe you touched on this in your testimony, but as we've already shown, I struggle with pinpointing testimony today.
No problem at all.
So how much would an RSP subscriber pay to purchase RECs on their own versus their net cost to go through this and have Ameren retiring them on their behalf?
So, I mean, I think that it's hard to pinpoint that there's one number that they would, but there is a market for RECs and they can purchase those. We worked with our, kind of marketing function to look at what the market price of RECs is. And we felt like what our, kind of what we call the implied cost of a REC under the programs, if you look at their net payments and how many RECs they get and divide that out and say this is the cost per REC, that it was in line with what they would pay. But I think one of the big differences is this gives the customer an opportunity to kind of lock in a 15-year term at a known price. The visible market that we worked with our, kind of like, again, our marketing function on, that will give you a price for the next, I don't know, it's 2, 3, maybe you can see out to 4 years, but there's really not a product that I'm aware of or that our folks were aware of that would kind of give you visibility to 15 years. So what it really does is for both sides of the transaction, which is the subscriber and, the company, it gives you some certainty to locking in a certain amount of value for those RECs.
I think you touched on this in your testimony, but the secondary market for Ameren to sell those and how, walk me through how that, the trade-offs between what they would do. Can you
Sure.
refresh me on that?
Yeah, thank you. So you can, we as a company could certainly, those same markets that we went out and looked at what it would cost to buy RECs, we could market and sell our RECs there. Now, to me, there's two things. One is there would be uncertainty because that, we couldn't forward contract for 15 years to sell the RECs and figure out, how much revenue we would get. We would be kind of subject to market fluctuations over time. But to me, the bigger thing is if we sell those RECs to an entity that's outside of our service territory, then with that goes any legitimate claim that we're providing renewable energy to our customers. So, Mr. Dixon talked about in his testimony about how important it is for our customers to know that they're being provided with clean energy. We wouldn't be providing that clean energy to our customers if we sold it to third parties outside of the service territory, right? They'd be offsetting their own needs for renewables they might build somewhere else, and so we couldn't claim to be providing our customers clean energy, and any customers that were interested in that would then really not care that we built that solar because they don't get any claim to the renewable attribute of it, so to speak.
Excuse me, Chairman, is your microphone on?
I believe it is.
Okay, sorry.
I just need to turn it. OPC has talked about a 50-50 cost share.
Correct.
In your words, why is that not appropriate under this proposal?
So I think, there's been some history around cost sharing on voluntary programs, but I think the really important difference here is irrespective of this program, we brought this resource because it's a needed part of our forward-looking generation portfolio to serve customers. If you look at our generation portfolio, there's no other resource, there's no other generating facility where we share in risk. It essentially would make the renewable generation that we know we need going forward kind of almost second class in terms of cost recovery to the other types of resources, right? We have, it could be that Callaway doesn't cover its costs in a given year. It could be that any of our other facilities doesn't, but we don't take on that economic risk. And I think even if you read staff's testimony, they'll say once a resource is determined to be needed, its costs, its prudent costs, they should be prudent, of course, right? Our prudent costs should be reflected in the revenue requirement, and the risk that things don't turn out exactly like you thought they were at the time you made the decision shouldn't bear on shareholders per se, because they needed to build that resource or that asset or whatever it is in order to serve its customers.
So what is there as a protection for you to just underprice the cost of this program for participants to ensure that it is fully subscribed and just to make sure you have a fully subscribed program?
Well, I think one thing is, you can look at the prices and see if we've underpriced it. At the time that we priced it, we had full models that said what we expected the cost to be. But the larger point to me is that no matter what happens, having the subscribers is going to reduce costs for all customers. There's going to be net revenues that are coming in from that program. You say, it actually is I think, in non-subscribing customers' interests that we price it at a level that guarantees we attract enough customers. Because those customers are going to come in and pay something towards that resource. It's going to be the net of the program charge and the resource credit. But if we price it at a level that doesn't attract folks, we get no contribution from them. So we're left, maybe we can try to sell the RECs on the third party market, but again, we have no guarantee of what those revenues would be, and we would lose the clean attributes for the benefit of Missouri customers. So I guess what I would say to you, Chairman, is that if we happened to have underpriced it, and again, we used a snapshot in time of what we thought the costs were going to be, and our witnesses have said the cost has gone up since then. So we didn't knowingly underprice it, but the world has turned out that if you were going to, look at that cost, it would be underpriced from that perspective. but it's still beneficial to all customers because it provides a really good market, long-term locked in, essentially to provide value for those RECs that's going to lower the revenue requirement for all customers.
Maybe you're not the right person to ask for this, but my memory is telling me that Ameren had a solar proposal plan several years ago where they were going to put solar panels on top of commercial and industrial businesses. Basically, the business would not own the panels. It was just a, hey, let us use your roof. To my knowledge, was that fully subscribed or did that go anywhere?
I think that was called Solar Partnership Program, and I believe we had, I'm not 100% sure that there was not more, but there was at least one customer that we did do that with. And I wouldn't necessarily call it a subscription in that case, right? They weren't actually getting energy, they weren't getting RECs, but it was a partnership. It was a way to, you know, essentially work with our customers so that they could have, you know, the visibility of renewable resources and aid us in finding good locations for solar. And we could, you know, then develop a resource to serve all customers. I'm pretty sure we have one customer that we entered into a project and completed, and it's in service under that. There may possibly be more than that, but I am not 100% sure of it myself.
Did that conversation come up that when you were creating your pricing models that you wanted to have a solar project with commercial and industrial people that was fully subscribed versus the one that only had one customer, and so therefore you wanted to ensure that it would be fully subscribed?
So, I mean, I don't think the solar partnership, I don't think we were really even thinking about that framework at all when we were working. In fact, really what we were thinking about, we had a renewable choice program where we were trying to do something similar to this renewable solutions. That one just had some really program design issues that made it never really take off, but that's really what we were trying to replace. The solar partnership is really kind of a separate and apart from this model, the way I think about it, at least. I don't know if that's helpful or not, but.
No, I was just curious if that thought process was present during your discussions of pricing this. If the commission were to go forward with a 50-50 proposal, would you have to go back and renegotiate with all of your pre-subscribed clients?
Well, the only way we would have to negotiate with clients is if something changed in the tariff. So if, you know, I think the bigger question would be, because the 50-50, I believe, would impose the risk on shareholders, not the subscribing customers. The bigger question is, would Ameren proceed with the program? And I don't believe that we would plan to. You know, I mean, I guess if the subscribers wanted to take on the risk that we weren't taking on, there could be a negotiation around that. But my expectation is it wouldn't change the tariff, so it wouldn't kind of let the subscribers out of their commitment, but it would make Ameren, Missouri question its own ability to kind of go forward with the program.
Is there any type of penalty to Is there any type of penalty to a pre-subscriber for backing out of the?
There is a termination provision. So if a customer wants to back out, the first thing that we would do is try to market it, and we do have a substantial wait list of customers. So if there's someone who's willing to assume the subscription, then a subscriber can walk away, but you have a backfill for it on our list. If there is no backfill and they want out, there is a defined termination fee in the tariff, which essentially kind of looks at the commitment that they've made and projects what it would be and charges kind of that net amount under the contract. So it kind of projects what the net bills would be expected to be based off of whatever experience you've had in the program up to that point, and tries to recover the cost from that customer that would be terminating. Our preference would be for them to find a backfill subscriber, and at least at this point, we think that would be pretty easy because we have a lot of interested customers, on a wait list and/or just expressing interest.
So if you have a lot of interested customers on a wait list, do you think that you priced it competitively, or do you think it's everyone's lining up because it's one heck of a deal?
I think we priced it fairly, is my own sense. When I say the wait list, I mean they certainly haven't signed on at a particular price. So if we ran the price up, I think we would test that theory, right? And if we do another resource, we'll have to figure out what our pricing, philosophy is there. I'll tell you, when we did price this, we didn't know. We didn't know what the market would bear. And so we had to, do our best analysis of what we thought was fair. We looked at the prices of RECs in the market. We looked at the cost of the resource. We looked at the benefits of the resource and tried to figure out from all those, what did we think was a reasonable price? We were worried that it could be too high or too low. We didn't know that, no one would sign up, or we didn't know that we would get a flood. We can take that information back and try to do a better job, but it's always going to be, trying to feel out what the market is, in addition to really looking at what's fair in terms of the costs that of the project and of RECs and things like that. So it is a balancing act for sure, pricing a program like this. To me, the real question of is it priced well is that it's going to make a significant contribution to affordability for all customers, and it's at a price where we were able to subscribe it and bring that benefit forward.
I think that's all I have, Judge. Thank you.
All right, thank you, Chairman. Do any of the other commissioners have questions for the witness?
No questions, Judge. Thank you. Bolzman.
Thank you, Commissioner. All right, I've got some questions myself. Mr. Wills, have you been here all day?
Yes, I have.
So you've heard other witnesses testify?
Yes.
Okay. I'd kind of like to touch on what I asked Ms. Forsberg as far as the investment tax credit versus the production tax credits. Can you, well, first of all, do you agree with her that use of the investment tax credits generally is benefited by a tax equity partner?
I definitely agree, pending the kind of the IRS guidance that Ms. Forsberg was talking about. If the transfer of ITC credits is subject to normalization, which we don't know right now, then I do think it's tax beneficial. If it's not subject to normalization, my personal opinion is I expect it probably wouldn't, but we would still need to do the analysis. We wouldn't decide that based off of what I just said right here. We would look at it closely at the time.
And I apologize if she explained this, but when you say normalization, does that just mean the ability to sell in the open market?
No, so the normalization, and let me try to explain it. I think Ms. Forsberg tried to explain it a little bit, but so if we invest, X dollars in a solar facility today, the investment tax credit would say you get 30% of X or 40% of X, depending on if it's in an energy community, as a tax credit immediately. Now, so that's cash that comes into the company. But IRS normalization rules say that when you're building your revenue requirement in a rate case, you can't provide the benefit of that cash to your customers to lower the revenue requirement today. You have to spread it out over 30 years. And that's we would prefer to give it back to our customers today. That's cash that's would improve the affordability. But they say that the normalization means you put that cash into your revenue requirement, and I hope I'm saying this from an account perspective right, but I think practically it's right. You have to spread it out and use offset rates gradually over 30 years rather than taking the benefit of all of that cash right up front.
But the company itself is able to use that, take a tax credit of 40% of the cost up front.
That's correct.
In-
And so we're looking
in
for
year
how
one.
can we make sure that we take that tax credit and provide the benefits back to customers? What's the best mechanism to do that in as close to real time as we can?
And then, can you compare that to the use of the production tax credits?
Sure. Well, so the production tax credits already come in over time, over the life of the product, because of the facility, because they're tied to production, right? So when the facility generates a kilowatt hour, we get a tax credit.
Right.
Next year it generates one, we get another tax credit. So it's already spread out over the life.
As opposed to project costs?
Right.
Okay.
That's right.
How do you compare the two tax credit programs to allowed return and amortization and those types of parameters?
I mean, we look at the impact on the net present value of revenue requirement. So in a revenue requirement, you know, the production tax credits would just come in as essentially dollar for dollar offset to the revenue requirement as energy is produced over its life. So you would just calculate your projected revenue requirements reflecting that offset to costs, right? If you're doing ITC, it's more complicated because you need to know, again, is it subject to normalization or not? But if it's not subject to normalization and that cash comes in, I believe the way it would be handled in a revenue requirement is it would just reduce the amount of rate base that you apply your cost of capital to. So, right, if you had X dollars of investment, but you got a 40% tax credit, you'd only put 60% of X in rate base to build your rates off of up front. I mean, and then I think as you just go through depreciation and amortization of the resource over time normally, but you would have cash benefit up front that would reduce rate base and reduce the amount of return that customers had to pay for the cost of capital of that investment. I hope that made sense. Or
Close enough. Would you agree with Ms. Forsberg when she said that the company hasn't decided on which of those two tax credit programs they're going to use?
Yes, that is correct. And part of that is because we're still learning about the rules that will surround these things. And then part of it is also because it depends on a trade-off between how much investment you're going to make versus how much production you expect. And we want to see how much investment it's going to take, plus get that additional IRS guidance about the rules that are going to impact it.
So when it comes to the cost of this project, can you kind of lead me through what the subscribers will be responsible for versus the non-subscribers?
Yeah, and there's so I'm trying to think the best way to do that because there's a little bit of complexity to it. So the easiest way probably to think about it is we have got this charge and credit, but there's going to be net revenue from that. It's going to be a positive contribution that offsets the cost of this. Now we're not trying to get down to the weeds of saying that it's paying for this cost versus this cost in the revenue requirement. We're just saying, look, there's a $12 million in the base case net present value benefit. That's going to offset some costs. Now there was some cost of service theory that underlies the way we get there, and so the way we got to the charge and to the credit. And so the cost of service theory we had was we priced it off of customers paying really slightly more than subscribers paying slightly more than 100% of the expected cost. So they would pay for everything that was expected. But we built the program knowing we did not intend to true up that cost to the actuals that come in over time. So variances in that cost would impact the revenue requirement. And just like they would with that, if this resource were done without the program, and we were doing it solely for the need, which we are doing it for anyway.
Can you help me understand what is behind why the estimated project cost has increased?
So I can give you what I know about it's going to be limited. Essentially, my understanding of it is the price of the actual equipment, the panels, doesn't get locked in until we have a decision to go forward. And various pressures on the solar panel market, I believe, are causing the estimate of what that cost will be to have increased. I'm not the person dealing with that up as close, so.
I've read a lot of testimony, and I apologize if if I get a little confused on the testimony, but Renewable Choice, was that a prior program that was similar to this Renewable Solutions program?
Yes, we have an effective tariff for the Renewable Choice program, and there are many similarities between it and Renewable Solutions. Renewable Choice just though had a few design issues we learned about as we tried to both subscribe customers and acquire projects to serve that program that caused it never gelled, so to speak. We never got some resources lined up. So this is an attempt to kind of fix some of those problems and make something that works.
I believe in your direct testimony, you said that with the Renewable Choice program, you didn't like the idea that the credit was being linked to market prices. And so the Renewable Solutions program was developed based on a fixed price, correct?
Right, and I would say more so it was we didn't believe our customers who wanted to subscribe liked it being linked to market prices. And we had real trouble, getting people over the hump to sign, a commitment to participate in the program, not knowing kind of what the cost per kilowatt hour of the the credit per kilowatt hour of their generation would receive. So that was a kind of a learning from the program.
And is the RSP based on fixed revenues?
The RSP? Yeah, so the charge is fixed. So say a customer wants 10 megawatts of capacity dedicated to them. We'll take 10 megawatts times the rate stated in the tariff. Actually, the tariff is stated in per kilowatt, so we would take 10,000 kilowatts times the rate stated in the tariff, and that's their bill, regardless of how much for the charge side. The credit is what gives them benefits in proportion to the amount of energy that it generates, and again, that's something that helps absorb some of the production risk so that it won't impact non-subscribers.
Is there a risk of market revenue fluctuations that falls on the subscribers or the non-subscribers?
Market price fluctuation?
I called it market revenue.
Well, so because if the market revenues just due to production level changes, all or the majority of that would fall on subscribers. If market prices change, just like with any of our other resources that we use to serve all customers, the benefits of higher prices would go to all customers and the cost of lower revenues would go to all customers. So the market price is kind of impacting non-subscribers, but the volume is impacting subscribers. So that's something that doesn't exist with any of our other resources. If any of our other plants' production declines, there's no hedge against that from a program. So we are able to shield subscribers non-subscribers from a certain amount of market risk that they wouldn't be shielded from if the resource were done without the program.
So the subscribers to the Renewable Solutions program, for what they pay, are they Are they paying for renewable energy credits?
I mean, you can think of it that way, certainly.
Indirectly?
Yes, I mean, that's right. So basically, they're saying that, you know, certain customers really do care about buying what they call a bundled product, I think, where the energy source is also providing energy, and, you know, by virtue of the fact that it's on our system, you know, that is meaningful to some of our customers. Some customers care about just buying a REC. At its simplest level, they're paying for a REC. But the fact that we can bundle it as a tariff product in our service territory is a meaningful distinction, I think, to some of our customers.
And again, maybe, I don't know, maybe the answer to this is indirectly as well, but are they paying for the energy that they consume?
So they're paying their base tariff still. So they pay 100% of their underlying tariff. So they're paying for the energy that they consume at the underlying tariff. Again, I think we did come at this program, you know, looking at it through a variety of lenses, but the easiest way to think about just what you've said is that they're kind of paying an implied rate for a REC to go on top of the energy they're paying for under their base tariff.
Are they paying for the capacity costs of the project?
That's what the renewable resource charge is based off of, yes.
As it stands now, or how it's envisioned, will the plant be included in the rate base?
Yes.
And how will that cost be recovered from customers?
Just through normal base tariff rates. So it would get reflected, it would get built. We would have to have a rate review where we were resetting rates. We would calculate a revenue requirement that included that in rate base, and rates would be set based off of that level going forward. You know, the benefit of the program is that there would also be certain revenues coming in that would offset some of that would also get reflected in the revenue requirement to reduce the total cost. But you would see both pieces in a revenue requirement calculation. The full cost source would be reflected in those rates, and so would some benefit from the program as an offset to it.
And would that cut across all ratepayer classes?
Yeah, because our assessment of need for this is the need to serve all of our customers. We need energy resources to serve all of our customers.
Okay. I mentioned the renewable energy credits a second ago. Do you know how many RECs will be produced by the project?
We have an estimate. So the easiest way to get there, Ms. Forsberg talked about I think 25.6% net capacity factor being the expectation. So what you would do is you'd take 150 megawatt capacity times that 25.6% capacity factor times the number of hours in a year, 8760 hours in a year. There actually happens to be a calculator sitting up here. I can do that if the calculator works.
State property.
I've got a calculator on my phone that might be faster if you want me to do the math on it. Oh, you know what? It was in that.
Yes,
it was in my testimony also.
I was going to say, but does your phone spit out a paper tape?
But there was a table in my testimony also. So renewable energy to subscriber kilowatt hours. In the base case, it was 339,012,000 kilowatt hours. So that's 339,012 megawatt hours, if you want to think of it in megawatt hours. That's the base case, and you can, in my testimony on page 40, table 1, there's also a low generation and a high generation case.
And is that your direct?
My surrebuttal.
Surrebuttal, okay. I see. If you know, what is the current market value of the RECs in Missouri?
I don't know with a lot of specificity. We looked at some numbers with our trade group, and really, if I said them out loud, I'd be going off of a memory that's a few months old because we did it when we were doing the pricing exercise here. There is information in like our renewable compliance plans, our demonstration that we've complied with renewable energy standard. We buy RECs there, and there's numbers reported in that report. I feel a little unconfident in putting a number out there because it's not fresh in my mind exactly what those are. I will say, though, it was the range that we had in my direct testimony, there's an implied cost of REC that we say that the subscribers will be paying. And I felt and we felt as a team putting this program together that it was very much in line with what we believed the market was at that time. So, for example, in my direct testimony on page 18, I said that the implied cost of a REC to the subscriber at the P50 level was $3.91 a REC, and at the P75 production level, it was $5.62 per REC. And at the P99 production level, we said it was $10.36 per REC. Now, at that P99, that to me was well above what we believed the market was at that time, but it was also a very low probability of occurring. The P50 and the P75 at $3.91 and $5.62, we thought were in line with the market of what a customer would pay for a REC.
Now, do the value of RECs fluctuate over the life of the renewable generation asset, whether it be solar or wind?
It depends on how you're selling. If we sell them under a contractual commitment, that price is set in the contract. But if we were to just sell them on the market, yeah, that's absolutely subject to market price fluctuations.
What would cause those fluctuations?
Just general supply and demand of RECs in the market.
If we were to separate out the Renewable Solutions Program and the commission were to approve only the CCN for the solar project, would those RECs be owned by Ameren, Missouri?
Yes.
And could Ameren, Missouri monetize those RECs?
Probably, assuming that there remained a liquid market out there to sell to. To me, I still think it's in our interest to sell them to our own customers for the economic development reasons that I talked about earlier and that Mr. Dixon talked about. And we could potentially still sell them to our customers. I mean, we'd have to enter a new agreement to sell them. But for as long as there continued to be demand, then yes, we could sell them.
Would those RECs be sold throughout the life of that project?
They should be. And we'd have to continue to evaluate, what the best thing to do with them was, whether there was, a contract to enter into, or whether we valued for economic development and other reasons to make sure that they went to our load. We might retire them on behalf of our load. There'd be a variety of options that we would consider.
And I'm hesitant to ask this question because it may reveal my lack of knowledge about the RECs and Ameren's role with them. But in the past, has Ameren had these RECs to sell?
No, we've been, in fact, we've bought, in given years, we've bought RECs to comply with Renewable Energy Standard. I think the other thing is that we can, under the Renewable Energy Standard, we can bank RECs for up to 3 years. So I don't think we've ever gotten into a position where we had RECs that wouldn't go towards either our Renewable Energy Standard requirement in a given year or into our bank that could get used. It's possible that I'm forgetting about a time when we've ever had excess RECs. I haven't gone back right before this and reviewed every, res compliance filing that we had to refresh my memory, but my recollection is that we haven't sold off excess RECs. That's to the best of my recollection. It certainly hasn't been a lot.
Does Ameren have a policy whereby they retire those RECs?
Yes, certainly for Renewable Energy Standard compliance assets, we retire them, specifically pursuant to the requirement under the RES standard. I don't think we've had excess RECs beyond that. Like I said, to my recollection, if we have the program, we'll set up a policy that they'll be retired on behalf of subscribing customers.
And how does that benefit the customers?
It's essentially they own the attributes of the renewable energy, so they can make public statements that they're served by 100% clean energy, emissions-free energy, meets their sustainability goals, it meets, things like that.
If the RECs that result from this Boomtown project are owned by Ameren, Missouri, and they are eventually retired by Ameren on behalf of subscribed customers, will the non-subscribers see any benefit from the retirement of those RECs?
If the program, I'm sorry, was your question if the program is happening or if it's not happening?
Well, I mean, if it's happening if the scenario is Ameren receives those RECs, those RECs, and sells those, retires them on behalf of the subscribed customers, will the non-subscribers receive a benefit from that?
Well, certainly they'll receive the benefit of the revenues. I would argue that they also receive a benefit in terms of it. They are being retired for load in Missouri, which when you talk about the business climate, and Mr. Dixon earlier talked about how businesses that are trying to site here and locate here that create economic activity in our service territory and that help pay for the fixed costs of our system care about knowing what is the energy mix in that territory. And we can legitimately claim that our energy mix is cleaner if they're retired for customers in our territory. So the benefits to me are, one, the revenues that they would get from the program, from the subscribers, and two is essentially the reality that clean energy is in Missouri, and that provides a lot of enhancements in terms of those things like economic development and things like that.
If the project produces excess RECs, how will the sale of those benefit customers?
Every REC that gets produced, as long as the program is fully subscribed, every REC that gets produced goes to a subscriber.
And then how would the company treat those revenues?
They would all go back to non-subscribers. Every dollar of revenue that comes. So we actually proposed a tracker in this case because it's possible that due to the operation of regulatory lag, Ameren, Missouri shareholders would just essentially benefit from the revenue from those RECs. We wanted to make it 100% clear that we're trying to promote the affordability of the resource for non-subscribers. So we proposed a tracker that every dollar that comes in from this program gets deferred so that it can be amortized in rates as an offset to revenue requirement to reduce rates for all of our customers.
Outside of this Boomtown project, is that how the sale of RECs have been treated, where they benefit all the ratepayers?
So outside of it, they've been retired just for res standard compliance. So they don't produce revenues. We're not allowed to sell them and also retire them for res compliance.
All right, I'm going to change the subject a little bit and talk about Illinois. And Illinois has recently passed legislation, and I think you speak to it in your rebuttal.
Yes.
And it's aimed at reducing carbons, and I think the legislation itself states that it reflects or maybe this was your testimony, reflects the, quote, political reality that supports renewable development in the state, along with the need for capacity in Illinois, which is MISO Zone 4. And the state's obvious preference for emission-free sources. I believe that was in your rebuttal. Are there any Missouri laws that demonstrate a similar preference for additions of renewable energy in Missouri?
I think the res standard is recognized as a policy preference for renewables. There's a number of commission orders that I cited in my rebuttal testimony where the commission relied on that, not only as, we have to meet that renewable energy standard, but that it does say in some of those orders, if I recall correctly, that indicates just a policy preference that this commission has kind of expressed towards renewables. Now, there's not any legal requirement that we go above 15% renewables, but I think that has been recognized by the commission in certain cases as kind of being representative of the fact that there is a policy directive to support renewable development in the state.
Does Ameren, does their recognition of the differences between Illinois and Missouri as far as politics go mean that in practice Ameren will only pursue additions of carbon-intensive generation facilities in Missouri, despite the need for capacity in both Illinois and Missouri?
So are you asking, like, if we were building a gas plant, would we take Illinois off the table as a place to, I think the law would, I believe the law would take it off the table, and I think.
Illinois' law would?
I believe it would. You know, and if not, I do think it would give us significant pause, even if the law didn't prevent it, because I think we would take that into consideration for sure.
Quote unquote, the political realities in Illinois, Missouri.
Yeah.
Okay. Will there be any impact of the Clean Air Act on compliance for your generation facilities in Missouri?
Any impact of the Clean Air Act?
Has the Clean Air Act, I guess, affected the company's decisions on how and when to retire coal generation facilities and so forth?
Speaking to which exact environmental regulations were most impactful would have really been Mr. Michael's wheelhouse, but I will say that the existing and potential for new environmental regulations absolutely has, you know, impacted, you know, our view on the need to transition and the kind of risks around the lives of our existing coal facilities and natural gas facilities, for that matter. But as far as, you know, which specific regulation drives what decision, it would really be a question that would have, unfortunately, would have been better suited to Mr. Michaels earlier.
Can you speak to the decision on siting these panels in Illinois? Is there any risk in that going forward as far as the political climate in Illinois?
From the political climate, there's nothing that I can think of that would create greater risk around solar development in Illinois from the political climate.
Is it possible that the Illinois legislature could also pass legislation that might change the perception of its receptiveness of renewable projects?
I mean, I suppose in the future, anything is possible. I find it unlikely that they would shut down existing resources that are providing service over something like that. They might move away from a preference for promoting more new development in that way. I mean, anything's possible in the future, right? But
is it possible that, well, I guess, again, anything's possible, but is it possible that Illinois lawmakers could pass land use restrictions that could affect additional installations of solar in Illinois?
I like you said, I imagine anything's possible. I don't know too much about those issues and how they would be perceived in Illinois, but so I probably can't really say too much more about that.
Has Ameren, Missouri, given thought to the possibility that there might be future restrictions on the mining of heavy metals and rare earth and components that would be needed for the production of battery storage?
I think probably so. I mean, that's really something that's outside of my line of sight, really, in the things that I'm involved in day to day. So I'm not really well positioned to answer your question on that.
Okay. All right. I'm going to test both of our memories, but early on when Mr. Aurora testified, I was asking him about the preferred plan resource timeline. In the preferred resource plan, in regard to 700 megawatts of wind coming on line in 2021, and then in 2022, 827 megawatts for the Merrimack Energy Center retired. Does that mean that Ameren, Missouri is currently short in capacity 127 megawatts? I'll ask that question first.
Okay, and I would say no, it doesn't. And the thing that and I think Mr. Michaels got into this a little bit, but we were already long capacity when we had that. But we're not really looking at this in terms of a one-for-one exchange of capacity. We're looking at what are our forward-looking needs and what's the mix of the right type of resources there. So when Merrimack retired, that didn't create a short capacity position for us, and so there wasn't any kind of one-for-one consideration of a new resource to replace that on a capacity basis.
But it's fair to say, right, that
our relative length got less by that, by some amount at that. If that's where you're going, I'm sorry, I didn't mean to jump your question.
No, all I was going to, I don't guess it's so much a question, but there is a concern, is there not, long term, with the retirement of the coal and gas generating facilities having to be replaced and having to meet, and again, I apologize if I get the terminology wrong, but the capacity to replace those plants.
Absolutely, and that's really why we think that the right lens to look at a resource decision is the integrated resource plan. Because, I mean, the integrated resource plan looks at all of those factors in an integrated fashion. That's why we call it that, right? And so, our plan does have quite a bit of renewables in it, and those have a certain amount of accredited capacity value, but it is lower than some of the other resources. That's why it's really important that we've started doing this, what we call all hours probabilistic. Mr. Michaels talked about the Astrape analysis that we do earlier. We're trying to pick the right attributes of resources to construct kind of what does our fleet look like in the future when it's meeting really the three pillars that I talked about in my rebuttal testimony, that it achieves all of the three pillars of affordability, reliability, and sustainability. Reduce emissions, still provide that level of reliable service to customers in an affordable manner. And you can't do that by just looking at what's the one resource I need next and then wait and then to say, okay, now what's the one resource I need next? You need to do a thoughtful staging of what does that new fleet look like and build it in a systematic manner over years. And so the combined cycle that we've got in 2031 will help with that capacity element. We've got a certain amount of battery storage in there. And then these energy resources, these carbon-free energy resources that'll help meet, sustainability goals, but also provide the low-cost energy that we need will be a part of that. We're designing kind of this vision of the future fleet, and you can't do that by one at a time saying, okay, now what's the next problem? 2027 winter, let's go get something for that. That's not how it works. You have to build this with a vision for the entire process.
Earlier, you referred to that table 1 in your rebuttal testimony. It's on page 40. Yep. It's got columns for low generation, base, and high generation. Ms. Forsberg testified to the p-values. Are there p-values that kind of correspond with low generation and high generation and base?
There definitely are. I'm trying to remember because I don't know if I noted them in here. I know the base is 50, P50. That's no doubt. Subject to check, and I don't know how I can check while I'm up here, but I believe it was maybe 25 and 75. It's something in that order. Piece 25 on one end and piece 75 on the other. They were symmetric. I can tell you that, and
meaning the same.
Yeah.
Right, the same distance from base?
Right.
Okay. Since we are on rebuttal testimony, on page 50, Missouri industrial energy consumers or customers, witness Maurice Brubaker. You were asked about him supporting the request for the CCM, but suggesting that the program price should be lowered. You testified that the pricing was fairly set and not designed to fluctuate in order to, quote, true up subscriber costs precisely to experienced costs, and then in parens, and benefits. If tax credits or grant funds resulting from the Inflation Reduction Act or the Infrastructure Investment and Jobs Act are utilized, if the subscriber would not experience the benefit from the resulting reduced project cost, who would?
Non-subscribers.
Non-subscribers?
All customers.
Where would those benefits show up?
They would show up as an offset. Well, so if it would show up as either an ITC or a PTC. We talked earlier about how those get reflected in the revenue requirement. So those would get reflected in the revenue requirement to reduce rates for all customers.
All right, I want to shift gears a little bit. And you've heard me ask other witnesses this, but when it comes to the operations and maintenance costs for Boomtown, will the subscribers contribute to those costs?
I would answer that with yes, and let me maybe clarify that, the renewable resource charge included an assessment of the estimated cost of the resource, including O&M. So there's a base level of O&M expectation built into the renewable resource charge rate. Now, just like everything else, we didn't plan to true that up, right? So if the O&M comes in a little higher or a little bit lower, actually that's something that the company would experience regulatory lag on at first and would be absorbed by the company for a period of regulatory lag. And then once rates were reset, the new level of that O&M would impact non-subscribers. But keeping in mind that there was some base amount of that built into the renewable resource charge that subscribers are already covering. So it's really just the variation in that from the levels that we projected at the time that the program was designed.
Okay. I believe that's all the questions I have. So, Ms. Pleshia, do you have follow-up questions?
Yeah, I just have a few questions, Mr. Wells. Is it correct that RECs are now gets created when a solar panel generates energy?
Solar panel or another qualified renewable source, I think that's fair to say.
Okay. And can you generate solar energy without RECs? Without getting RECs?
I mean, I think you could not go through the process of certifying it perhaps and not get a REC, but I think it inherently has the capability, anything has the potential, is a potential REC, I guess I would call it.
Right, but there's no way that you can generate solar energy and not get a REC.
That's fair.
It's going to generate a REC.
That's fair.
So would you agree that it's fair to say that there is no incremental cost to Ameren by producing the REC?
Yes.
Okay, no other questions, thank you.
All right, Mr. Opitz.
Mr. Wells, you recall a little while ago, you and the chairman were discussing the price that subscribers will pay. Do you?
Yes.
Customers who've subscribed will continue to pay their existing tariff rates, correct?
Yes.
And so this subscription is something that would be an additional charge that they're voluntarily undertaking, correct?
That's correct.
That's all I have. Thank you.
All right. Mr. Thompson, any follow-up?
No questions, Your Honor.
Ms. Greenwald?
No questions, Your Honor.
All right. Mr. Williams.
No, thank you.
Mr. Graham.
Yes, sir. Yes, sir.
All right.
Mr. Wills, you remember the questions that the Commissioner asked you with respect to risk-sharing arrangements, and your answer that staff had stated that when a need is established, then the risk should not be, and staff had admitted that the risks of the project should not be shifted to ratepayers. You remember saying that?
I do.
And were you referring to testimony that you had read from?
Yes.
Were you referring to Mr. Lubert's testimony?
Yes.
May I approach the witness?
Yes.
I think everybody's got this. It's pre-filed. I'm going to hand you, I'll go back to my microphone. Handed you exhibit number, what I believe to be one, what number is that? 105. And I'll represent to all other attorneys in the room that that is the rebuttal testimony of Jay Lubert that has been long on file in EFIS in this case. I'll direct you to page 10.
All right. Page 10.
Right. And line 6. I'm going to read to you, and you correct me if I read this wrong.
All right.
Mr.
I apologize, Mr. Graham. I'm going to interrupt and ask you to speak more into the microphone. Thank you.
Thank you, Your Honor. Once the need is established and the project is determined to promote the public interest based upon the best information available at the time, it is reasonable for ratepayers to assume the risk that that project selected, is uneconomic. First of all, did I read that correctly?
I believe you did.
Is that the testimony you were relying upon?
That's at least one part of it. There may have been others, but that's part of it.
Well, let's look at the rest of it. Does he go on to say this assumption of risk is justified because absent the load of the ratepayers, the utility would not be obligated to invest in additional resources? Did I read that correctly?
Yes.
That's what Mr. Lubert said.
That's right.
Let's go on to the next question. Does that same principle hold when a given project is either not necessary to serve the needs of ratepayers, is not an economically efficient use of resources, or is not in the public interest? Did I read the question correctly?
I believe you did.
And did Mr. Lubert state, no, captive ratepayers should not be expected to shoulder the risk that an electric generating plant built beyond the energy and capacity needs of the ratepayers being served is uneconomic? Did I read that correctly?
I believe you did.
Let's look at the next thing that provides the context that you were looking for. Question, are these solutions to avoid this unnecessary risk to ratepayers? That's the question. You understand that?
I understand that.
And then did Mr. Lubert say, yes, the commissioner's role as the regulator of the monopoly is a key protection against the introduction of unnecessary risk by utility management on behalf of ratepayers. The commission has typically exercised this role through the application of the Tartan factors, considering the request to build new generating facilities, ensuring that all of the Tartan factors met by the utility and ensuring that the utility provides all crucial supporting analysis that establishes needs, economic feasibility, and promotion of the public interest. If the commission determines that adding additional renewable resources is appropriate, I'll read that again. If the commission determines that adding additional renewable resources is appropriate, but recognizes the potential risk of uneconomic outcomes should not be borne solely by the ratepayers, it is within the commission's discretion to condition approval of the CCN. One potential solution is for the commission to condition any potential approval of an asset with a hold harmless provision that would shift some of the risk of an uneconomic outcome back to shareholders and away from the captive customers. Did I read that correctly?
I believe you read it correctly.
And isn't that indeed exactly what Mr. Lubert stated in total with respect to the single statement that you had picked out and quoted to the commissioner? Isn't that what Mr. Lubert actually said?
I'm going to object. I think it mischaracterizes Mr. Will's answer. He said these are some of the statements that you may have relied on, but that's not all of the statements.
I'd like an answer to that's an objection? Or is that an
Object to the
argument?
form of the question. Misstates the witness's testimony. Assumes facts not in evidence.
Mr. Graham, can you rephrase the question?
Well, I'll just rephrase the question. Mr. Wills, is this what Mr. Lubert said in providing the rest of the text of his answer that you quoted one sentence from?
Well, I didn't quote that one sentence, but what I'll tell you is I think this whole statement still supports exactly what I said. The question you read is, are there solutions to unnecessary risks to ratepayers? We are making the case that's necessary. So I don't think that was relevant to our disagreement was whether this is necessary, right? But I'm putting forth to the commission that this is necessary. If that's the case, I don't care what the sentence says. What do you do with unnecessary risks? There aren't any.
Well, there is certainly a risk that you have, and every Ameren witness has admitted to, an absolute risk. Indeed, as far as I can tell from listening to Ameren, a certainty that this project will not generate revenues sufficient to cover its costs.
Objection states facts not in evidence. No Ameren witness has testified that it's certain that the revenues from this resource won't cover its cost.
I'll rephrase the question. Isn't it true that Ameren has stated repeatedly in response to my questions that if those facts as I've stated them materialize, and that is to say that revenues do not meet expenses, isn't it true that Ameren has said that doesn't matter?
I believe I've said that should not be borne by shareholders. I mean,
okay.
if that's what you're getting at by doesn't matter. I mean, we do care about the revenues. We think they're good for our customers, but if they don't materialize, just like there's no revenues from the transformer outside my house, but those costs are needed to serve customers, and they're reflected in the revenue requirement that's used to set rates.
Let's get this straight then. You stated you believe, in response to questions, that Ameren will not pursue this project with a hold harmless.
That's my expectation that's a management decision, but that's my expectation of management's decision based on what
I'm sorry, I didn't mean to step on you.
Just based on the conversations I've had, that's my expectation of what management's decision would be.
And you've stated that that's a justified conclusion because if the need is as great as you stated is, that the ratepayers should pay the whole freight, right?
Correct.
And so your conclusion from that is that if that need is that great and you are nevertheless ordered by the commission to task yourself with a hold harmless provision, you will not build this project even though it's as great a need as you've said it is. You just won't do it.
If the commission tells us it's not as great of a need as we've said it is, then that means that we will listen to them and realize that it's not as great of a need, and we'll have to regroup and find something else to do to meet that need.
Fair enough. I have one more. Okay, a couple more questions. Does the implied program, this is on a different line, I think a follow-up on what the judge was asking you, does the implied program cost per renewable energy credit, RSC, decline over time? Does the cost of that implied program cost decline over time?
It may.
Okay.
I'd have to go back through, because the renewable energy, the renewable resource charge and the renewable benefit credit both escalate over time at different rates. And so the cost per rec in 1 year is not the same as the cost per rec in another year.
Okay. You mentioned that there is not an incremental cost for RECs.
Assuming you're building the generation already, right?
Okay. So there's not, I better get this right, an incremental cost of REC production. Is that right?
That's right.
Okay, is that true with a tax equity partnership?
I believe it's true. I mean, I don't know what would change about it. I can't think of what would change about it.
Thank you. I think that's all the questions staff has. Oh, I beg your pardon. You mentioned the ASTRAP, A-S-T-R-A-P-E analysis.
Yes.
Have you reviewed the cases evaluated in that analysis?
I've looked at them at some point in time. I didn't review them like yesterday to be able to rattle off a bunch of answers about them, but I have looked at them.
I'll try not to roll off a bunch of questions to you. If so, did ASTRAP, if you looked at some, if you don't know, if so, did ASTRAP consider a case that did not include solar prior to 2029? You may not know.
Yeah, you're correct. I don't know.
Okay. I believe that's it. Thank you very much.
Thank you.
And Mr. Graham, just so I'm clear on this, are you referring to that ASTRABI?
Yeah, I did the best I could with the
Okay.
pronunciation. It's an acronym. I think my pronunciation was right.
I don't know, is it an acronym? I didn't. I'm going to say it's not a river.
Don't believe it's an acronym either, Judge.
Okay, Mr. Lowry, do you have redirect?
I do, Your Honor. You were asked some questions, pretty sure this was by the judge, about O&M costs, and subscriber contributions to O&M costs of the Boomtown resource, correct?
Yes.
And you mentioned that because of regulatory lag, if those O&M costs go up, the company would actually, for a time, bear that increased expense, not the customers through rates, right?
That's correct.
If the company's able to drive O&M out of the operation of Boomtown, in other words, lower O&M, once rates are reset, who gets that benefit?
If it happens in between rates, then the company would get the benefit of it on a regulatory lag basis until the next rate review.
But once rates are reset, who gets the benefit, subscribers or non-subscribers?
Non-subscribers.
Judge asked you questions, I think, about possible legislation in Illinois, and you said anything's possible, right?
Right.
Like restricting use of land, for example, correct?
He mentioned that as an example. I didn't feel very confident in knowing the details of that issue, but yeah.
Is it possible the Missouri legislature might restrict land for solar?
Sure. I mean, in as much as it is in Illinois. And, I mean, I know more about it in Missouri than I do in Illinois, but in as much as anything is possible, it's possible in Missouri as much as in Illinois.
Judge asked you some questions about whether the value of RECs could fluctuate. Did he not?
Yes.
And I think you said, well, supply and demand could have an impact on that, correct?
Correct.
Do you have an opinion over, let's just say, the next 15 years, because the customers and the subscribers in the program would be locked in to buying the RECs at a certain price for 15 years. Do you have an opinion about what you might expect the price of RECs in the market to do over the next 15 years, given supply and demand?
Yes, I would expect them to, my personal expectation, this is my view of it, is that the prices would go down over time. If you look at the amount of renewables in the construction queues and the plans of utilities to build new renewables, I think supply of RECs is going to go up pretty substantially. You hear MISO talking about, potential world where there's 50% or more renewable penetration. That's a lot of RECs on the market. I think the supply side of that would be more likely to long-term decrease in REC costs, and by locking in for 15 years, I think that's a good thing. Again, my personal view on the market. There's, if I knew I was right, I'd go speculate on the market. And
you wouldn't be here answering questions from all of us today, right?
Right.
But if your personal opinion comes true, then locking in those RECs at a higher price than what that market price is going to be a benefit, right?
It's good for all customers.
You were asked some questions about the Renewable Choice Program. And if I could summarize, I think what you more or less said, if I can boil it down, was the program didn't work that well. We had difficulty getting subscribers, right?
Yes.
Is that why we went out and designed a program and actually got subscriptions before we proposed it?
That is exactly why we did.
You're not seeing those same kind of problems with this program?
No.
Excuse me.
Judge asked you some questions about tax equity partnership. Do you recall that?
Yes.
If the company determines that it's in the best interest of its customers to use a tax equity partnership in connection with the ITC, presumably because it thinks it has to because of the normalization rules you talked about, is the company intending to come back to the commission and get whatever permissions it needs to do that?
Yes, again, we withdrew our request for approval of anything related to tax equity in this case, so we would be back to get those permissions.
I think the judge asked you some questions, and I think this was, I don't know if it was about the tax equity partnership, but it certainly dealt with the tax credits, PTC versus ITC, and I think he asked about cost of capital in the two cases, maybe with a tax equity partnership or otherwise. Just so the record's clear, and I'm not sure this is even what he meant by the question, but so the record's clear, Ameren, Missouri's investment in the facility, if it uses the ITC in a tax equity partnership, we didn't assume a different weighted average cost of capital for Ameren, Missouri in that case than we would have assumed in a PTC case, right?
No, I don't. I mean, I didn't do the modeling. I have no reason to think we did, and I'm pretty sure we didn't.
If a tax equity partnership has to be used to get those benefits immediately to customers, with the ITC and avoid the normalization, is the tax equity partner, I mean, are they providing something that's akin to a loan? I mean, it's financing of some kind, right?
Yeah, it is financing. It's they contribute capital, and then they get a revenue stream to pay back that capital with a return. So
do you know whether or not the company would expect that cost of capital to be higher than its own cost of capital?
I probably should, but I'm not sure that I can say that I know for sure off the top of my head.
Okay. I know you were asked some questions about this hold harmless, certainly by Mr. Graham, and I think Chairman Roop asked you a little bit about it as well. When a utility installs a generator, for example, and the commission's decided it's needed because the commission has to allow us to do that, right?
Okay, I'm sorry, could you say that again?
And the commission would have had to decide it's needed if we install that generator because we have to get the commission's permission to do that, right?
Right.
Putting aside any regulatory lag between rate cases, if that generator performs way better in the market than everybody thought, does the company get to keep the upside?
In this scenario where it was hold harmless?
No.
Oh, well.
Just in the
Well, it
normal
doesn't
case.
matter, I guess, right? The hold harmless doesn't say you also get the, right, yeah, so, no, there would be no benefit to the company necessarily. That would still go back through the fuel adjustment clause as a benefit to reduce costs for all customers.
Yeah, my question really was sort of flawed, except for the 5% sharing, there's no lag. If that unit produces way more revenues in the market than everybody thought when it was approved and built, customers are getting 95% of that almost in real time to the fuel adjustment clause.
That's right. So that basically the economic risk of the unit can benefit customers, and nobody's asking us to, take away the benefit, but they are asking us to insure the downside. So we would be providing insurance for no upside, and the customers would get the benefits.
Mr. Graham, I think, in his initial cross-examination, asked you about need and asked you if you had either read, or I don't know if he'd asked you read Tartan, but he said needs one of the factors in the Tartan factors, right?
Yes,
And he asked you, I'm pretty sure, whether you were familiar with the Tartan factors, did he not?
he did.
Have you read the Tartan case carefully?
Yes.
Do you have an opinion about whether the approach that staff is taking to need in this case is consistent with how the commission approached need in the Tartan case?
Objection, his opinion on that score is irrelevant and immaterial and will not assist the commission in deciding any material issue in this case. It also is speculative and vague.
I think Mr. Graham asked Mr. Wills about need and whether or not he had reviewed the Tartan factors and the Tartan factor of need, and I think Mr. Wills can testify about his understanding of need based on the Tartan factors.
That's not the question that counsel asked, Your Honor. I'd ask the court to remember, the commission to remember the question, and the question was whether this witness had an opinion on whether staff's position was consistent with something.
Mr. Lowry, would you like to rephrase your question?
I'll take a shot at it, Your Honor. Let me ask about the company's position. Do you have an opinion about whether the company is approaching need in a manner consistent with the commission's application of the need factor in the Tartan case?
Objection calls for a legal conclusion.
I don't believe Tartan establishes the law, Judge. It's an administrative decision. The commission doesn't make the law, doesn't have power to declare the law. The commission has developed guidelines that it generally follows from Tartan, but it's not a legal conclusion I'm asking him for.
The fact that it is not a regulation or a law does not erase the fact that this witness is being called to express an opinion that is legal. It is not engineering opinion. It's not an accounting opinion. It's not a layman's opinion that's competent here. It's an opinion. And this witness is not competent to render an opinion that would be of use to the commission in deciding any material issue that's presented in this case.
Mr. Wills is the Director of Regulatory Affairs at the company, and he's an expert on regulation and rate making, and that's exactly what we're talking about here.
Overrule the objection. You can answer the question.
Do you remember the question?
No, unfortunately.
Could I ask the court reporter to just read it back, Your Honor?
Go ahead.
Application of the need factor in the Tartan case.
I'm going to
Another objection.
I'm going to object based on relevancy.
And I'm going to add that approaching an issue is vague and so general that the question cannot be answered. That's my objection.
Okay. Mr. Lowry?
Are you able to answer the question, Mr. Wills?
I feel like I could.
How do you respond, Mr. Lowry?
Well, I don't think the question if the witness is able to answer the question.
Judge, my basis is that his opinion about whether or not there's need in anybody's case is irrelevant. That's a question for the commission.
Judge, I don't think that's correct at all when you have Mr. Lubert testifying about the Tartan factors and applying them and giving opinions about what they mean, what need means under those factors. I think if staff can provide that testimony, this witness can certainly provide the company's viewpoint about the same issue.
I agree, and I'm overruling the objection, and if you still remember the question, you can answer that question.
I think I do. I think, so, yes, I do think that our approach to need is consistent with the Tartan decision. The Tartan decision, basically recognized that need did not mean absolutely indispensable, but it was an improvement justifying its cost. And so what that improvement that's justifying the cost could be is much broader than some narrowly defined issue. In Tartan, the commission took into consideration its own plans for expanding natural gas service to underserved parts of the state. It took into consideration economic development benefits that would arise from the project. It took into consideration customers' preferences so basically, the communities that were going to be receiving natural gas service had essentially solicited the company to come to them and deliver gas to them, and the commission took into consideration those customers' preferences, and essentially it looked at the totality of the benefits of that and said, do they justify the cost? So really, ultimately, what we're looking at is the totality of the benefits. We have, an energy need. We have customers who want new renewables. We have environmental risks that we have to prepare for our customers. We have a major job ahead of us to, build enough resources to replace all these retiring facilities over the next 2 decades. And the totality of those issues, to me, is easily justifies the cost. And I'm flummoxed really by the fact that we're even in need of it, to be quite honest.
The last part of that response be stricken is being flummoxed. I've seen that times in their testimony and their reports.
Well, I don't think that's necessary, so I won't strike that.
Judge, that's all the redirect I have. Thank you.
All right. Okay, Mr. Wills, thank you for your testimony.
Thank you.
And it is 4:41, and I know Mr. Graham must be out of here by 5 o'clock, and so I think if there's no objection, I think we'll adjourn for the day. Correct. So, 9 o'clock, correct. So we are adjourned for the day, and we're going off the record. I don't see how it can happen in 15 minutes, so we will start with him first thing tomorrow morning. Yeah, and, he's got some lawyering experience under his belt. Now he can ask his own questions.